and you don't expect me to allow her to.
Thank you so much. So we're going to be talking about a child-friendly justice system today, and I really want to observe all protocols. Thank you so much for this platform and this chance given to me. So firstly, I'll start by defining what a child-friendly system is in my own understanding. And I feel this is a justice system that should be accessible, diligent, and adapted to or focused on the rights and needs.
Yeah. Thank you.
Okay. Oh my.
Okay, go ahead.
Can you
Yes,
hear me now?
We can hear.
Can you hear me now?
Yes.
Okay, thank you. So I was saying thank you so much for this platform and this chance that I'm given to talk here, and I want to observe all protocols. So we're going to be talking about a child-friendly justice system, and in my own understanding, I feel this is a justice system where there should be accessibility, diligence, and adaptation, or focus on the rights and needs of a child. And the best interest of a child should also be highly observed in such a justice system. So I also feel that the right to protection and the best interest, as I mentioned earlier, are very important factors that contribute to a child-friendly justice system. In order for us to achieve it, we must have a child protection and best interest as highly observed. Thank you.
Thank you, Lubida, for your remarks. And now we shall have a video statement of His Excellency. Kindly mute your mics. For those people who are not presenting, kindly mute your mics.
Catherine, the host can mute everyone. You have that function. Maybe you could use it.
Good morning.
We are waiting for the video statement. Thank you.
Catherine, maybe the person running the video can unmute themselves so we hear the sound. There's no sound.
Kamini.
Bonjour Catherine, nous on n'entend pas très bien, hein, Catherine. On n'entend pas très bien le discours. Le premier a tombé ici à toi. C'est en portugais, toi.
Moi, pour intervenir, je peux intervenir.
Mandekal. Tem la tradução. De português. Eu vou traduzir em português. Vocês vão um pouco d'inspirer la réflexion. Ouais, c'est depuis qu'on prenne le manque de... Voilà, so, tout le monde. C'est vite, là,
Mais moi, je peux intervenir directement, non? Comment je fais? Alors, il y a de sérieux problèmes de son. Bonjour à tous. Bonjour à tous. Il y a de sérieux problèmes de son. Bonjour tout le monde.
On vous entend très mal, hein, madame. Madame,
oui.
Il y a des problèmes de son.
Oui, c'est ce que je dis.
C'est Augustin de la Mauritanie, honorable Augustin de la Mauritanie.
On behalf of Excellency the Chair of the African Union Commission, His Excellency Dr. Musa Faki Mahamat, I have the honor to make this statement on Africa's Children's Day. Our theme, access to child-friendly justice in Africa. Africa Children's Day was first conceptualized by heads of state and governments of the OAU in commemoration of 16th June 1976, when our students in Soweto, our children in Soweto, started the uprising in South Africa. Our young South African students marched in protest against the apartheid-inspired Bantu education, which was intending to prepare them for a future perpetual servitude under apartheid. They refused to learn Afrikaans. If we must learn Afrikaans, they chanted, Boza must leave. The march resulted in the public killing of many unarmed Soweto children. The first to fall was young Dr. Peterson, shot by the apartheid police and now forever immortalized by a memorial in Soweto. Since then, the Organization for African Unity and its successor, the African Union, have used June 16th every year to celebrate Africa's children. This day is intended to inspire sober reflection and dedicated action towards addressing a plethora of challenges that our children in Africa face and continue to face. This includes, though not limited, lack of education, child labor, lack of employment, child abuse, child soldiers, and child trafficking, among them. Child slavery as well. Africa celebrates this day to commemorate our children and the brave action they took to claim this right. The uprising in Soweto marked the beginning of the end of apartheid. This uprising of Africa's children was their demand to create the future they want. So we are obliged to invest in our children if we are to achieve the Africa we want. Now, following on this practice and on the basis of recommendations made by the African Committee of Experts on the Rights and Welfare of the Child, the African Union Executive Council of Ministers adopted, quote, access to a child-friendly justice system in Africa to be the theme for the Day of the African Child for the year 2020 in order to resonate with the theme of the Union for this year, which is silencing the guns. This year's theme calls on African member states to create and enhance a child-friendly justice system which is able to cater to the specific needs of all Africa's children, wherever they were, wherever they are in Africa and beyond. The African Union Commission recognizes that access to justice is a fundamental right. Access to justice is an essential prerequisite for the protection and the promotion of all other human rights. And this is especially true, even more so in the case of children. This can only be based on an all-inclusive education for all of Africa's children. That will ensure that they have employment and jobs and access to science and technology and development through this very science and technology to ensure innovation. Without ensuring access to justice, child rights commitments remain mere promises on paper that do not serve the interests of Africa's children. So we in the African Union recognize that progress that some of our member states have made in enhancing justice for children is great. These include child-friendly courts and dedicated law enforcement units. But we still have work to do to make this a living reality throughout our continent for all of Africa's children. The African Union Commission, therefore, would like to stress the need to create a justice system that responds to the specific needs of Africa's children. More is required to be done to ensure that the administration of justice in member states adequately responds to the rights and needs of Africa's children. As we speak today, we have to admit that in Africa, we are still far behind. We must ensure that detention is a very last resort to keep children in conflict. Because children in conflict need to be kept out of prison and taken to school. We need more schools for our children and fewer prisons. In the majority of our countries, the criminal justice system is yet to provide special treatment to children consistent with their dignity. Our children are frequently detained together with their parents and other adults. This is clearly not the best way to treat Africa's child offenders. Children whose parents happen to fall foul of the law in Africa are often an invisible and often highly vulnerable group. Their rights and welfare can be gravely affected at every stage of their parents' criminal proceedings and eventual terms of imprisonment. These children are often born in prison, and they often grow up in prison alongside their parents. This is clearly unfortunate and very sad. To address these challenges, therefore, the African Union Commission calls on member states to enhance efforts and to take the necessary measures to give Africa's children the justice they deserve. Today, as we commemorate Africa's Children's Day, we call on member states to recommit to work fully towards implementing the Africa Children's Charter, our Agenda 2063, and the Africa Union's Children Agenda 2040 to create the Africa we want. Now, the Africa we want can only be an Africa fit for our children. It can only be an Africa that today's children can be proud of when they grow to become the leaders of the continent, to be able to create the Africa we so fervently need. Thank you for your kind attention. I should like to have the honor to dedicate and declare today, Africa's Children's Day, and to wish Africa's children happy Africa Children's Day. Thank you for your kind attention.
Thank you for this statement by His Excellency Kwasi Kwati, the Deputy Chairperson of the African Union Commission. Now we welcome Her Excellency Commissioner Amira El Fadil, the Commissioner for Social Affairs, to give her remarks. Welcome, Commissioner.
Thank you, Catherine. My children, the sons and daughters of Africa, parents, mothers and fathers, ministers participating in this webinar celebrating the Child Africa Day, UN agencies, international organizations, civil society organizations, media, all participants, good afternoon. Assalamu alaikum wa rahmatullahi wa barakatuh. I start by thanking our Deputy Chairperson for his video message commemorating with us this Africa Child Day. Today, we commemorate the African child, and at the same time, deeply miss and mourn one of our members, Honorable Dr. Azza Al-Ashmawi, former first vice chairperson of the African Committee of Experts on the Rights and Welfare of the Child. Honorable Dr. Azza passed away on the 16th of April, 2020 in Cairo, Egypt. She was a dedicated and passionate defender of the child rights in both in her country, Egypt, and on the continental level. We pray to God to rest her soul in eternal peace and to continue comforting her loved ones and the people of the Arab Republic of Egypt. Please, I would like to request 1 minute of silence in her memory. Thank you. Rabbana yarhamah. Excellencies, as you are aware, the day we are celebrating today traces its history back in the 16th of June, 1976, students uprising its way to South Africa. Inspired by the aspirations and convictions of these young boys and girls, the African Union has dedicated June 16th African Child, where we celebrate children's resilience, power, and commitment in making social. Please, can you mute your mics, please? Please mute your mics.
Commission, you need to mute yourself.
Kameni, please unmute the speaker. She has been muted as well.
Sorry. Access to child-friendly justice, despite being of the fundamental rights of children, its realization is long overdue in our beloved continent. Being one of its major areas of focus, the Department of Social Affairs is undertaking activities towards enhancing the protection and promotion of children's rights on the continent. Activities such as the initiatives around combating harmful practice like FGM, child marriage, are the strategic pillars to protect children's rights in the newly adopted 10-year action plan to eradicate child labor, forced labor, human trafficking, and modern slavery. And the strategic responses to online child sexual exploitation and abuse that are coordinated through the Department of Social Affairs are our success stories that we all cherish. And this is our main priorities in 2019 and 2020. As the COVID-19 pandemic continues to evolve, the department takes the role in coordinating the development and implementation of an African Union comprehensive socioeconomic response to the COVID-19 health pandemic. Building on its role, the department is working with member states to ensure that their response to COVID-19 are tailored with the special vulnerabilities of children, particularly of girls. However, without ensuring access to justice, all our efforts and child rights commitments will remain futile. And let me also mention at this point that the Africa Center for Disease Control and Prevention, which is also under the Department of Social Affairs, is the African Union technical agency that leads the fight against COVID-19 in Africa. And the Africa CDC is mandated by our heads of states and governments on their decision in their first meeting on March 26 that Africa CDC should lead the implementation of our joint continental strategy on COVID-19. Excellencies, ladies and gentlemen, as we commemorate the day, we do recognize the positive trends and the measures undertaken by member states in complying with their obligations in ensuring access to justice for children. However, we also note that in a majority of countries, the measures undertaken are only at an early stage, and in some cases, they are lacking entirely. In most countries, justice systems often fall short of their obligation to ensure that children are treated with special care in line with their evolving capacities and special rights. Many countries in Africa still set their minimum age of criminal responsibility below the internationally recommended standard. Others are yet to establish children's courts while sentencing children to life imprisonment,
please mute your...
even to death. The justice administration procedures fail to respond to the rights and needs of children, as most of our countries still prioritize detention as opposed to non-custodial solutions such as pretrial diversion programs. Excellencies, ladies and gentlemen, we have noted that separate detention centers are hardly available in most countries, as others are facing lack of duly trained staff who can respond to legal, psychological, social, emotional, physical, and cognitive needs of children. These facts are indeed manifestations of our major limitations, and they remind us the amount of work which remains to be done to provide children in contact with the law the special treatment they deserve in line with their protected rights. There is a need for a deliberate and strategic intervention to address the persistent barriers that children are facing against the fulfillment of their rights in the justice system. Hence, commemorating this day, I call upon member states and stakeholders in extensive consultation with children to work together towards deliberately establishing or strengthening a comprehensive and coherent national policy and strategy for children in the justice system, which shall consider the interrelatedness of the challenges that children in contact with the law are facing. I would Also like to reiterate the African Union's call on member states to strategically work towards full implementation of the African Children's Charter, guided by the principles included in SDG 2030, Agenda 2063, the Africa we want, and Agenda 2040, Africa's agendas for children's rights. Excellencies, ministers, participants, I would like to commend, before concluding, the role of our committee, as a committee, all the members of the committee, the chair, the two vice chairs, all the members of the committee. We commend highly the role played by this committee. Excellencies, as I conclude, I call on all stakeholders to put our efforts together to work towards an Africa fit for children. Shukran jazilan. Shukran jazilan. Happy Day of the African Child from Addis Ababa. And sorry for some of the connections problems we are having here. I do apologize, and I welcome you again to this webinar. We will be following all the presentation, and I wish you a very fruitful deliberations. Thank you very much. Shukran jazilan, and assalamu alaikum.
Let me look at the sent messages. Okay. Thank you, Excellency, for your statement and your encouragement. Now, Honorable Sidiku, the second Vice Chairperson of the African Committee of Experts on the Rights and Welfare of the Child, to give her remarks. Welcome, Honorable Sidiku. I was not muted from here, maybe from your computer or from recent MIS.
Merci, Madame. Et bonjour à tous. Chers enfants, Excellence, Madame la Commissaire des Affaires sociales, Mesdames et Messieurs, tout protocole respecté. Je me réjouis au nom du Comité africain d'experts sur les droits et le bien-être de l'enfant de votre présence en ligne ce matin pour la commémoration continentale de la Journée de l'enfant africain 2020, la 30e du genre. C'est le lieu de saluer la présence parmi nous des enfants d'Afrique et aussi de nos illustres hôtes qui se sont joints aux enfants et à nous-mêmes ce matin pour commémorer leur journée. Merci encore au vice-président de la Commission de l'Union africaine pour son message. Merci également à ma sœur, Madame la Commissaire des Affaires sociales, pour sa contribution et son engagement sans faille pour la cause des enfants. Je tiens à remercier les ministres et chefs de délégation des États membres de l'Union africaine pour cette collaboration fructueuse en vue de la célébration de cette journée commémorative de la Journée de l'enfant africain. Ces remerciements s'adressent tout d'abord aux enfants qui se sont préparés pour cette journée dans tous les pays africains avec beaucoup de créativité en vue de rendre cette journée mémorable, mais aussi aux partenaires qui accompagnent chaque jour le travail du comité et appuient la mise en œuvre de la charte au niveau national. Chers enfants, mesdames et messieurs, l'accès à une justice adaptée aux enfants en Afrique est le thème sur lequel le comité nous invite à réfléchir au cours de cette année et plus particulièrement au cours de cette journée entièrement dédiée aux enfants. Le choix de ce thème a été guidé par une réflexion faite par les enfants eux-mêmes sur les thèmes qu'ils souhaitent voir abordés pour leur journée d'une part, et sur le constat fait par le comité sur la mise en œuvre de la charte par les États parties d'autre part. En effet, conformément à la Charte africaine des droits et du bien-être de l'enfant, l'accès à une justice adaptée aux enfants est le fondement du respect de tous les droits garantis, dont un certain nombre de dispositions aux articles 4, intérêt supérieur de l'enfant et respect des opinions de l'enfant, l'article 17, administration de la justice pour mineurs. L'article 18, protection de la famille et protection des enfants en cas de dissolution du mariage. Article 19, soins et protection des parents. Article 24, adoption. Et article 25, séparation des parents, qui exige une justice adaptée aux enfants. L'accès à la justice est un droit fondamental en soi et une condition préalable et essentielle à la protection et à la promotion de tous les autres droits humains. C'est donc un moyen d'exercer d'autres droits de l'homme universellement reconnus dans de nombreux cas. Malgré le fait que ces droits existent sur le papier, l'application de ces droits est bien trop faible dans la pratique. C'est particulièrement vrai lorsqu'il s'agit d'enfants. En l'absence de mécanismes efficaces de protection des droits de l'homme, les enfants sont souvent exposés à des abus et se heurtent à d'importantes difficultés pour exercer leurs droits, y compris dans le cadre du système judiciaire formel. En choisissant le thème « Accès à une justice adaptée aux enfants en Afrique » pour la commémoration de la Journée de l'enfant africain 2020, le comité aimerait souligner l'importance des droits des enfants à accéder à une justice adaptée aux enfants pour la réalisation des droits des enfants en Afrique et tient aussi à souligner la nécessité de créer un système de justice qui réponde aux besoins spécifiques des enfants. Outre de nombreux facteurs économiques, structurels et institutionnels tels que la complexité et le coût des procédures judiciaires, les contraintes géographiques et physiques, les infrastructures physiques inadéquates, les structures administratives ne disposant pas de capacités suffisantes pour gérer les systèmes, les capacités judiciaires limitées et une profession juridique incapable de servir le grand public font que l'accès des enfants à la justice est limité par plusieurs obstacles spécifiques aux enfants. En outre, la législation et les procédures concernant le traitement et la participation des enfants aux procédures, y compris les procédures pénales, administratives et civiles, ne sont souvent pas adaptées aux droits et aux besoins des enfants ou peuvent même être discriminatoires à leur égard en raison de leur âge et de leur sexe. C'est ainsi que le comité tient à souligner que, pour garantir un accès effectif à une justice adaptée aux enfants, les systèmes juridiques nationaux devraient avoir la capacité d'accepter et de traiter les plaintes émanant d'enfants ou déposées en leur nom. Et ceci tout en respectant, protégeant et garantissant pleinement leurs droits. Pour ce faire, il est nécessaire de créer un système de justice qui tienne compte des besoins spécifiques des enfants, en particulier des principes fondamentaux et des dispositions pertinentes de la Charte africaine des droits et du bien-être de l'enfant et de la Convention relative aux droits des enfants. Chers enfants, mesdames et messieurs, fort de ce qui précède, le comité a déjà élaboré une observation générale sur l'article 30 de la Charte concernant les enfants de mères emprisonnées. Il a ainsi noté que les enfants vivant en prison avec leur mère sont victimes d'une série de violations de leurs droits qui s'accompagnent généralement de problèmes psychosociaux et de santé, ainsi que de difficultés d'accès à l'éducation. L'incarcération parentale peut également entraîner des difficultés pour les enfants vivant séparés de leurs parents, telles que des difficultés financières et matérielles, de l'instabilité dans les relations familiales ou des changements de domicile. Cette situation peut causer une dégradation des performances scolaires, une humiliation et une stigmatisation sociale et institutionnelle. Dans certains États parties, les parents sont mis sous pression pour renoncer à leurs droits parentaux en cas de condamnation. L'incarcération peut également nuire à la perception qu'ils ont d'eux-mêmes en tant que parents. Les répercussions psychologiques peuvent être comparables à celles résultant d'une autre forme de perte telle que la mort ou le divorce, bien que certaines répercussions soient différentes. Le comité, à travers cette observation générale, voudrait, entre autres, préciser le champ d'application de la loi, des politiques et des pratiques nécessaires pour assurer l'application complète de l'article 30, s'engager dans un dialogue constructif avec les États partis sur le cadre constitutionnel, politique, juridique et opérationnel pour la mise en œuvre effective de l'article 30, promouvoir et encourager la soumission de rapports périodiques réguliers par les États partis, qui précisent notamment les mesures constitutionnelles, politiques, juridiques et administratives prises afin de s'acquitter de leurs obligations en vertu de l'article 30. Mettre en évidence des approches positives concernant l'application de l'article 30 en profitant de l'expérience de suivi du comité et des recherches sur le sujet. Les rapports des États partis soumis au comité ont montré la prise en compte de ces recommandations qui ont été renforcées par les lignes directrices pour une justice adaptée aux enfants, élaborées par African Child Policy Forum et approuvées par le comité afin de relever les défis des pays africains liés à l'accès au système de justice des enfants en Afrique. C'est ainsi que le comité a souvent recommandé, concernant le problème des enfants qui sont détenus avec des adultes, que les États partis fournissent des mécanismes et des structures à l'extérieur de la prison pour s'occuper des enfants en conflit avec la loi. Dans les cas où la détention est inévitable, le comité recommande fortement à ce que les enfants soient détenus séparément des adultes dans tous les établissements pénitentiaires du pays et mettre en place des tribunaux pour enfants et d'augmenter le nombre de psychologues et travailleurs sociaux dans le système de justice pour enfants en se référant aux lignes directrices citées ci-dessus. Un système judiciaire adapté aux enfants requiert que les enfants qui entrent en conflit avec la loi soient traités de manière respectueuse de la condition d'enfant et qu'ils soient offerts une assistance juridique gratuite. Cette exigence s'étend à tous les enfants suspects ou victimes d'un crime, tout comme à ceux qui font appel au système judiciaire pour assistance. La détention d'un enfant doit toujours être utilisée comme une mesure de dernier recours pour une durée qui soit la plus courte possible. Des mesures alternatives à la détention ainsi que des services de réadaptation et de réinsertion pour les enfants doivent être utilisées et mises en place. L'implication de la reconnaissance du droit à un système judiciaire adapté à l'enfant est conforme à l'agenda 2063 de l'Union africaine, à l'agenda 2040 pour les enfants d'Afrique et à l'agenda 2030, qui offrent tous une approche nuancée à l'amélioration du système de justice pour enfants en Afrique. Les gouvernements africains doivent réaffirmer leur engagement, entre autres, à utiliser des mesures proactives pour améliorer le système judiciaire pour faire face à la violation des droits de l'enfant, prioriser la protection et la promotion des droits de l'enfant avant, pendant et après le procès pour obtenir le résultat escompté de l'aspiration 8 de l'agenda 2040 et plus largement de l'agenda 2063. Élaborer des stratégies qui indiquent les mesures à prendre pour faire en sorte que l'intérêt supérieur de l'enfant en conflit avec la loi soit pris en compte. Prioriser les mesures alternatives à l'emprisonnement des enfants et favoriser la réinsertion sociale. Chers enfants, mesdames et messieurs, cette année, le comité n'a pas voulu se laisser freiner dans la protection des droits des enfants par la pandémie de la COVID-19. Il a même trouvé que c'est en ce moment difficile, notamment pour les enfants, qu'il doit redoubler d'efforts et d'actions pour s'assurer de la prise en compte des enfants dans la réponse à cette pandémie. Le thème de la journée de l'enfant africain de cette année est d'actualité à cause de la COVID-19, qui a amené le comité à élaborer une note d'orientation pour la prise en compte des droits de l'enfant au cours de cette pandémie. Ces directives ont été présentées au cours d'une session ouverte au Conseil de paix et de sécurité et ont été envoyées à tous les États membres. En effet, les enfants d'Afrique ont souffert et continuent de souffrir de cette pandémie. Il est essentiel pour l'élaboration et la mise en œuvre des stratégies globales et continentales d'inclure les enfants et que les données statistiques prennent en compte les enfants de moins de 18 ans. Le programme suggéré par le comité au cours de cette commémoration comprend des panels de discussion sur les thématiques qui, on l'espère, vont aborder la problématique globale de l'accès à la justice des enfants autour de 5 panels avec des panélistes qui partageront avec nous leurs expériences. C'est pourquoi j'invite les délégations présentes en ligne et tous les États membres qui commémoreront cette journée conformément au thème et à la note d'orientation COVID-19 à envoyer au secrétariat du comité un rapport suivant le canevas des rapports de la commémoration de la journée de l'enfant africain 2020. Je voudrais remercier l'ensemble des partenaires qui ont appuyé techniquement et financièrement le comité et son secrétariat dans l'organisation de cette cérémonie commémorative. Encore merci à toutes les délégations des États membres de l'Union africaine et à tous les enfants qui se joignent à nous pour cette activité en ligne. Sur ce, je déclare ouverte la commémoration continentale de la journée de l'enfant africain. Je vous remercie.
Thank you, Honorable Sidiku, for your very comprehensive statement. Now, I will give the opportunity to Her Excellency, Commissioner Amira, to give some remarks. Yeah.
Excellencies, participants, we miss today our chair of other committee, Honorable Mr. Joseph Diaz, and would like to give my condolences to him and his people and the government of Burundi for the passing of His Excellency, the President of Burundi. So our condolences to all, and we send his condolences through our chair, and we tell him that we miss him today. Thank you.
Thank you, Excellency, for the condolences. Now we are done with the opening statements, and we'll go to the panels, starting with the first one that will be on international and regional norms and standards on access to child-friendly justice applicable in Africa. The purpose of this panel is to set the context. The presentations outline the major norms and standards, both legally binding and non-binding, to ensuring access to justice for children with specific reference to the African Children's Charter and Aspiration 8 of Agenda 2040. The panel will also present the major disparities between the standards regional and international levels and those at the national level So at this time, I want to invite Mr. Ayelo Getachew Asefa. Ayelo, welcome.
Thank you very much. Thank you, Catherine, Excellencies, representatives of member states, and Excellency Commissioner of Social Affairs, and all protocols observed. Would like to welcome you again to this webinar where we're going to reflect on the theme of the year for the Day of the African Children's Charter, the African Child, where the Executive Council decided to be on access to justice, find child-friendly justice in Africa. As we have spent a lot of time for the opening, for the purpose of saving time as well, I'll try to be as brief as possible, just highlighting the major international and regional instruments with regard to access to child-friendly justice system and the jurisprudence and standards and norms that we have, both at the United Nations level and at the African regional level. This is like a kind of a setting context kind of presentation. The upcoming presentations and the discussions are going to focus on these standards and norms. So it's just that for us to know where these standards are coming from. So I would like to project my presentation. I'm not sure that you can see it. Catherine, can you confirm that it's on, please? I can't be sure from my side.
Yeah. No.
What about now?
Okay. We can see it now.
Great.
Thank you.
So as I've said, my presentation is going to focus on just to let you know where we get the norms, standards, and the principles and jurisprudence with regard to access to justice in Africa. And our colleague, Dr. Violet, will be speaking on where we are with regard to these norms and the standards at African level. Which countries are actually complying with these international standards and the principles, including what we have at the African regional level. So basically, these are the main questions that I'm going to answer on. The first one is, what are the elements for access to justice for children? What do we mean by, after all, like what does it consist of? Second, where do we get the applicable standards and the principles, as I've said, both at the international and regional level? And third, fundamental, what are the fundamental principles of access to justice for children, and what are the general principles and elements of the access to justice for children as we get them from international and regional normative standards. First of all, not only for the purpose of this webinar, but from literatures and from international norms and standards, this is the definition that we adopt when we also develop the concept note for the commemoration of the Day of the African Child this year. So we advocate that access to justice for children should be defined broadly, where it refers to all procedures, whether they're judicial or non-judicial. They can also consist of administrative procedures, whether they are formal or informal. So it can be a justice procedure and system which relates to the judicial proceedings as we know it, and the formal legal system, or an informal systems like traditional and religious institutions and tribunals and courts. Or it could also relate with civil matters, like, for instance, issues related to care and protection of children, cases of foster care, adoption and placement of residents, family law matters, like proceedings relating to custody. They can also fall under the issues of access to justice. Like in most of the cases, when people think about access to justice, we tend to limit it with only criminal justice system and related with only with deprivation of liberty, detention and detention centers, which is of course the major issue. But the access to justice for children, as we celebrate it today, goes beyond criminal jurisdiction, criminal matters, criminal issues, and it could also include civil matters, as it's been indicated here, and of course the criminal issues as well. It can also be related with administrative law matters. So access to justice for children could be an issue when it comes to immigration procedures, for instance. Like for instance, migrant children could be asylum seekers. They may apply for permanent residence in a particular country. So these processes also consist of the access to justice aspect when it comes to children. And of course, issues related to actions of schools on disciplinary bodies, and accessing social assistance like social security benefits and birth certificates and birth registration. These all form issues of access to justice as we celebrate it today. So the children, their capacity could be victims in a particular case, they could be witnesses, or they could be alleged offenders. So the children could also come to these organizations, these procedures, these mechanisms in different capacities. So when we talk about access to justice, and when we try to understand access to justice, we need to define it in a more broader way so that it can encompass all these aspects where children could come in contact with the law in different forums for different reasons. Now, what kind of treaties, standards, and guidelines do we have at the United Nations level? Of course, we don't have time to go through all these instruments, guidelines, and standards and principles, both at the United Nations level and the African Committee, the African level, which is mainly the African Charter on the Rights and Welfare of the Child. So we'll just focus on the major international treaties and jurisprudence that we have, just to mention them as a source. But as you can see, starting from the 1985, the Beijing Rules, what we call the United Nations Standard Minimum Rules for the Administration of Juvenile Justice, to the United Nations Guidelines for the Prevention of Juvenile Delinquency, which a term which is now considered to be somehow not child-friendly. There are a number of organizations, as it's been projected here on the PowerPoint, as you can see, slide. These also, can we please mute our mics and video so that, yeah, we can proceed. Thank you very much. So we also have the United Nations Standard Minimum Rules for the Treatment of Prisoners, the United Nations Guiding Note for Justice for Children 2008, the Human Rights Council resolutions, the United Nations Model Strategies and the Practical Measures on Elimination of Violence Against Children in the field of crime prevention and criminal justice, Human Rights Council reports, the United Nations Special Rapporteur or a Special Representative to the United Nations Secretary General on Children Deprived of Liberty reports. All these documents, reports, resolutions, they consist of different principles with regard to access to justice for children. But the most important and of course binding rules and principles are included and prescribed under the United Nations Convention on the Rights of the Child and its optional protocols and the general comments that the monitoring body of the United Nations Convention has developed. The United Nations Convention, of course, you can refer to different articles like Article 3, 9, 12, 19, 37, and 40, and you may get very relevant provisions, standards, and the principles when it comes to access to justice for children. The optional protocol on the sale of children, child prostitution, and pornography, it actually prescribes issues related to access to justice, particularly considering children as victims and witnesses in this particular matter. So you may also get these principles and norms in this particular optional protocol. The optional protocol on communication, what we call the OP3, also provides child rights litigation at the global level, which is also another opportunity. But we also have very important two general comments developed by the United Nations Committee on the Rights of the Child. The first one was a general comment on number 10, which was developed in 2007, but modified and amended and revised just recently by the United Nations Committee. And they call it the General Comment number 24, which deals with juvenile justice, which actually raises the minimum criminal responsibility, the age of criminal responsibility from the age of 12 to the age of 14, but of course, progressively to age of 15. At the African level, we have different standards, and I'm remaining with only one slide. different standards. We have the Kampala Declaration on Prison Conditions in Africa, 1996, the Robben Alliance Guidelines of 2002, the Principles and the Guidelines on the Rights to a Fair Trial and Legal Assistance in Africa, 1999, the Lilongwe Declaration on Accessing Legal Aid in the Criminal Justice System in Africa, 2004, Principles and Guidelines on the Rights to a Fair Trial and Legal Assistance in Africa, 2003, and of course the guidelines developed by the ACPF and endorsed by the African Committee of Experts in 2012, what we call the guidelines of the on the action for children in justice system in Africa. And of course, recently, as you know, the African Committee of Experts has developed Agenda 2040, which we call the agenda the Africa's Agenda for Children's Rights, which is also adopted by the African Union policy organs, which also includes principles and guidelines on issues related to children in the justice system. But the African Children's Charter, being one of the most important treaty instrument at the African level, it also consists of various important principles and guidelines when it comes to access to justice. And of course, as the representative of the African Committee of Experts has mentioned, the committee has also developed a general comment on Article 30, which is on children of imprisoned mothers, fathers, parents, and caregivers, as it's been prescribed in Article 30. And finally, looking at all these treaties, charters, guidelines, and standards, what do we get? And we get what we're going to discuss today. The various procedures, the various mechanisms, the various protections, the various safeguards that we really have to provide to children using these principles and treaties. And of course, we get the fundamental principles of on issues related to children in the justice system, which relates to the participation of children, best interest of the child, non-discrimination, rule of law, and elements of due process, prohibition of torture, cruel and inhuman treatment, child-adapted systems, institutions, and mechanisms. These are part of the fundamental principles that we look at today as we discuss access to child-friendly justice system, as it's been reflected in international and regional instruments. And of course, we also get the elements of child-friendly justice system, which also includes the minimum guarantees and the rights of children during pre-trial, during trial, during sentencing, post-trial, that is during detention, if it's a criminal matter, minimum guarantees on issues related to information and privacy, diversion programs, alternative to custody, legal representation, and of course, training professionals and mechanisms to respond to the cognitive, social, and legal needs and psychological needs of children in all these processes. So these are the international instruments. Of course, they're not exhaustive, they're not comprehensive. These are the major international instruments, the major regional instruments that we have, which could be relevant to the discussions that we're going to do today. This is what I have from my side. Sorry for beyond a bit from the time limit. Please don't learn from me. Thank you very much. Over.
Okay. Thank you, Mr. Ayelo, for your very comprehensive presentation, for setting the pace by expounding on the different capacities that children may find themselves in the juvenile justice system, the relevant documents, the instruments. And now I'll invite Dr. Violet Odala, the Program Manager, Children and the Law at the African Child Policy Forum. Welcome, Dr. Odala.
Thank you, Catherine. And
j'aimerais bien prendre la parole. Bonjour à tout le monde.
All protocols observed. Can you just confirm that you can see my presentation?
Madame Catherine, c'est honorable. Est-ce qu'on peut avoir la parole dès que vous terminez vos communications? Est-ce qu'on peut avoir des copies de ces importantes présentations de nos collègues.
Can you see it now? Okay. All right.
We can.
Okay, thank you. So all protocols observed, I have been given the difficult task of presenting the status of legislative responses to child-friendly justice in Africa in 7 minutes. So it's a very difficult task, almost impossible, but I will try my best just to focus on the broader issues, which will help us engage in the conversations that come. The good thing is that on the program, we have presentations that are focused on country-specific examples, good practices, which are going to, from which we'll learn more about how various jurisdictions are implementing child justice in Africa. So the first thing that I will jump most of these slides because the previous speakers have already alluded to some of this. And just to reiterate the fact that when we talk of child-friendly justice, we are talking about justice that is specifically tailored to the needs of the various groups of children. And child-friendly justice begins in law and allows children to seek redress. So it has the potential to influence the future course of children's lives. That's why the theme for this year for the Day of the African Child is very important, because everything else about promoting children's rights rests on the extent to which we are able to provide redress for violations of children's rights. So that's why child justice has to be as child-friendly as possible in all respects. So as the elements of child-friendly justice have been alluded to by Ayalo, but just to project a few more here, we have, and I'll quickly go through them just so that we have them at the back of our mind. The issue of information and advice to children and protection of privacy, very important, safety of the child, limited use of detention, legal aid and representation, expediency, that is dealing with matters concerning children as quickly as possible, monitoring and oversight, information and feedback, participation of children, due process guarantees, and training of professionals, and system strengthening, adopting a system strengthening approach. So there are two key issues here. The legislation that provides mechanisms for dealing with children, and also dedicated institutions for ensuring redress for children, which must be backed by law. The problem that we have in Africa is that in some cases, we do have institutions that are not necessarily established in law. So it all depends on the political will of the policymakers for the to ensure continuity of those institutions. Once a certain policymaker leaves office, we see a lot of institutions also crumbling, thereby affecting the extent to which children can access justice. So institutions must also be backed by law. That's why law is very important, and we're saying that child-friendly justice begins in law. So how have we done in Africa in terms of adopting laws on children? So far, we have at least 35 countries that have consolidated statutes on children, and we have more that have draft laws on children. And for example, the bills that are still outstanding, we have Burkina Faso, Cameroon, Cabo Verde, Niger, and Zambia. And so it's very important to have specific laws on children. 30 years since the adoption of the Convention on the Rights of the Child, as well as the African Charter on the Rights and Welfare of the Child, it's very important to ensure that laws are harmonized, laws on children are harmonized with these international instruments, as well as those instruments that Ayalo spoke of, and the standards that are found in documents that are not necessarily binding, but have got a legal force in protecting and promoting children's rights. So the 4 broad areas that the law should concern itself when looking at children and ensuring access to justice for children are the criminal justice, civil justice, administrative procedures, as well as customary, traditional, and other informal alternatives. So these are the areas, and I'm glad that Ayalo mentioned that the fact that there is too much focus on criminal justice. And as you will see as I present, most of the examples that we have pertain to criminal justice. There's a limited focus on civil justice, more so on administrative procedures for dealing with children, almost existent in our laws and policies. So in the criminal justice arena, we deal with children accused or recognized as infringing the penal law. These are sometimes referred to as child offenders, even though that is not so much a child-friendly term. But more importantly, the issue of victims of crime, child victims of crime and witnesses. This is also where we see a lot of gaps in the laws and policies of on children in Africa that not sufficiently providing for child victims and how to deal with child victims and witnesses in the justice system, whether it's in the criminal justice system. So here, the elements that are critical are procedural and also substantive. So on the procedural aspects, the issue of prevention of crime for children, arrest and alternatives to arrest, pretrial alternatives and detention, the trial itself, and then sentencing that focuses on detention as a measure of last resort. But once you have sentenced a child and they have served their sentence, the issue of reintegration, especially where you have children that have been deprived of liberty within the course of the criminal justice system. So on substantive issues, we deal with the law should provide for minimum age of criminal responsibility, and the issue of criminal records, where international standards require that there's limited access to the records of children so as to protect their privacy. So when we look at the statutes on children that have been adopted by African countries, countries like Botswana, Ghana, Kenya, Lesotho, South Africa, South Sudan, Malawi, Tanzania, and Uganda and Zimbabwe do have specific provisions that protect the privacy of children. And this is very, very important because it enables the children to be dealt with without necessarily in the justice, without necessarily stigmatizing them when their records are being made available anyhow. And also the issue of treatment of children in detention. So with regard to minimum age, how have we done? Because this is very critical for criminal justice, because it determines whether or not a child can be dealt with in the criminal justice system. So the age at which the child can be dealt with in the criminal justice system. And so far, the guidance that we have at international level, based on the revised General Comment number 24 of the CRC committee, is 24 years. But on the continent of Africa, the guidelines that were adopted and endorsed by the committee in 2012 do provide for 15 years as the minimum age of criminal responsibility. And this is gotten from the AU Fair Trial Principles, which also provide for the age of 15. So this is how we're doing in Africa. As you can see, we have all those countries that now do have their minimum ages below the minimum age of criminal responsibility below the age of 14 years. So this is quite a lot, almost like 38 countries that we're looking at, I think, that are still yet to comply with international and regional standards. And if we look at 15, the African standard, it will even, the number will even increase here. So another issue, as I said, one of the key elements is the issue of sentencing children in the criminal justice system. So one key thing is the prohibition of corporal punishment as a sentence for crime. And this is how we are doing in Africa, that we have corporal punishment is outlawed in all settings, only in 7 countries so far. And it's prohibited as a penal, prohibited in penal institutions and as a sentence of crime in at least 44 countries. And you can see the list here. When you go below there, you will see the countries that are not prohibited where it's not prohibited in the penal justice system. So in terms of victims and witnesses, this is where we have major gaps in African laws, that we don't have many countries that do provide sufficiently for child victims and witnesses. And a good example is South Africa, where the law is quite comprehensive on this, and other countries can learn from this. It even provides for a register to record persons who for example, who sexually abuse children. So as a way of protecting children from further being victimized by offenders. And on the issue of in the civil justice system, the key issues are issues of child care and custody, but also guardianship issues, and the issue of unaccompanied and separated children. And here in Africa, there's also a major gap in terms of the law on which, in terms of the laws, national laws and policies on this. But we have seen a good progress amongst African states on how they provide for care and protection, because some countries do have dedicated chapters on this in the child protection. For example, the Malawi Child Care Protection and Justice Act, and South Africa has a specific act on child protection and child care and welfare, and issues of foster care, adoption and placement are not necessarily provided. I mean, foster care are not necessarily provided in laws in Africa, in most African countries, and it's important that they should ideally be made through by a court. But foster care, as we know, is more of a communal way of dealing with children here in Africa. So that's where we also have one of the major gaps on this one in the laws. And then when we come to the issue of inter-country adoption, because this also involves the justice system, as the committee, our distinguished member from the committee mentioned, we are also lagging behind in that most African countries have not adopted or ratified the relevant conventions, like the Hague Conventions, which specifically focus on this. And these conventions are very important because they do provide for central authorities, which require that laws establish central authorities for dealing with children to ensure that their due process rights are sufficiently taken care of when they are being adopted. But there is a major gap here in Africa on this one. So in the interest of time, I will go to the issue of customary and informal alternatives for children, where we know that this operates parallel to the formal justice system, and are at least partially recognized in some countries, laws of some countries, and there is a trend, although not as significant as it was supposed to be 30 years after adopting the Charter on the Rights and Welfare of the Child, a trend in codifying customary law practices as part of the new legal system. And examples of this can be seen in, for example, Uganda, where the Children's Act introduced the community or village court system, which can inform and resolve disputes concerning children. And there are also other examples of countries which I have listed there: Malawi, Zambia, Namibia, Sierra Leone, South Africa, Tunisia, and the like. But still more, there is need to provide, to codify customary law as a way of making sure that the standards and principles contained with regard to dealing with children in customary courts, for example, and the traditional justice systems align with international and regional standards in Africa. So quickly, in general, what we're seeing is that the child-related laws that have been passed, or bills, are quite many in Africa. But when it comes to access to justice for children, the focus is on criminal justice, and even within criminal justice, the focus is on children who have committed crimes and not children.
Excuse, Violet, we are
Yes.
giving you 2 more minutes, please.
Yes, actually 1 minute and then I'm done. Yeah.
All right, thank you.
Yeah, so the focus is, even within the criminal justice, the focus is on those who have committed crimes as opposed to child victims and witnesses. And there's also limited legislation focusing on civil aspects other than care and protection. So the issue of children, administrative procedures for children, for example, procedures that take place in schools that where children have to defend their rights, they are not sufficiently codified in law, and that is an important aspect of the justice system that we also need to take into account. And so to finish, we have seen that there is very limited documentation of the extent to which African countries have aligned their laws and policies with child-friendly justice standards. As we speak now, continental overviews of on child-friendly justice, we can actually speak of, for example, the report that SCPF and DCI produced in 2011 that led to the development of the guidelines on action for children in the justice system, the report Achieving Child-Friendly Justice, which was a 2011 report, and it needs to be updated. And also there's need to also focus on specific, like the vulnerable groups of children, like the girls, as well as children with disabilities and children in refugee or unaccompanied and unaccompanied children, how the justice system provides for them, because not many laws on children do provide for these groups of children. So I jumped through most of the slides in the interest of time, but we will make this presentation available. And I would also like to encourage you all to read, to access the reports that I've mentioned, Achieving Child-Friendly Justice in Africa, which is very important as it covers the whole spectrum of the 4 areas in which child justice laws must focus in order to ensure that justice for children is friendly in line with international and regional standards. Thank you.
Thank you, Violet, for unpacking the legislative responses by African countries, harmonization and major discrepancies, and apologies that we had to request you to cut short your presentation in the interest of time. So the stage has been set for the panel discussions. And now I would like to invite Honorable Nanike to take over the next panel. Thank you.
Thank you very much, Catherine. May I recognize Her Excellency, Commissioner for Social Affairs, Madam Amira. I hope I can be heard. Is that clear? I also recognize our Vice Chairperson, Honorable Sidiku, and say hello to everybody present in our commemoration of Day of the African Child 2020. Now going to the panel discussion, and our panelists are going to be talking to the issue of protection of children, and that is protection of children in the justice administration system with a focus on pre-trial and diversion, protection measures for children deprived of their liberties, protection and detention centers in Africa, which will be a general overview of the situation. And then we will have a presentation or discussion on major challenges and proposed solutions for children deprived of their liberties, norms, and practices. So without further ado, may I give this opportunity to Madam Sandra Sanyanga, the National Coordinator for the Pre-Trial Diversion Programs of Zimbabwe. Madam Sandra, you have the floor. Thank you.
Afternoon to everyone. Hello, can you hear me there?
Hello, yes.
Okay, thank you very much.
Yes, we can hear you.
Okay, I wanted to share my presentation with you guys, but unfortunately I'm being told that I can't share whilst the other presenters' presentation is still showing. So I don't know, the moderators, can you clarify the? Hello?
Hello. Yeah, thank you. Hello, can you assist that the presentation is shown on the screen, please?
Is it showing now?
Yeah, not yet, but yeah. Yeah, now it's fine. You can go ahead.
Okay. Thank you very much. I'm going to do my presentation on the Zimbabwe Pretrial Diversion Program. I'll share with you the overview, the achievements, and the challenges that we have achieved, that we've been faced with so far. Zimbabwe has made great strides in introducing the Pretrial Diversion Program, which is in line with various international and regional pieces of legislation that actually support the introduction of a pretrial diversion program here in Zimbabwe. By definition, we are saying pretrial diversion is the channeling of cases from the formal criminal justice system to extrajudicial programs under certain conditions and at the discretion of the prosecution. So these cases are dealt with by non-judicial bodies, thereby avoiding the negative effects of formal judicial proceedings and a criminal record on the child. They aim to provide the children with opportunities to rethink their lives without getting a criminal record. The current legislation that is in place to support the implementation of pretrial diversion in Zimbabwe, we have the Criminal Procedure and Evidence Act, particularly Section 9, which is the Prosecutor General's powers or his representative. They have the powers to decline to prosecute in any matter. This is the legislation that we're currently writing on, which is why you find out that in our definition on what pretrial diversion is here in Zimbabwe, we actually indicated that it is under certain conditions and at the discretion of the prosecution. So it is the prosecution that actually have the ultimate decision on whether to actually divert a matter or not. The Zimbabwean Constitution, hello? Hello? The Zimbabwe Constitution, particularly Section 81, which states that the child's best interest guarantees and enshrines children's rights to the extent that children should only be detained as an option of last resort. We also have the Children's Act, which actually says where the young person is homeless or in need of care, he may be placed in a place of safety. We also have the pretrial diversion guidelines, which were developed by the National Steering Committee. These actually support or help to guide the program implementers on how to go about the implementation of the program. And then we also have work in progress, which I believe is actually a progressive piece of legislation, which is the Child Justice Bill. It is now at drafting stage, and the coming in of this act will usher in a new era of a child-friendly justice system, which is supported by a sound legislative framework, which will hold service providers accountable. Then the rationale of having a PTD program. Many a times children commit offenses not out of their own making, but are victims of various socioeconomic factors such as poverty and homelessness, which leave them vulnerable and prone to commit offenses. Our formal justice system was seen to be unnerving and stigmatizing.
Sorry, Sandra, can you slow down a little bit for the interpreters, please?
Okay, I hear you. Our formal justice system was seen to be unnerving, stigmatizing, and hardening. Yet in most instances, when supported, young people can grow out of their crime. So by this, we mean to say that we need to give children a second chance. Usually when we expose them to hardcore criminals in our prisons or in our formal justice system, they end up being hardened and end up maybe failing to grow out of the criminal behaviors that they would have adopted or learned from the adults. So to prevent children from receiving a criminal record early in their lives and being labeled as criminals, as this could be a self-fulfilling prophecy. Once a child obtains a criminal record at such a tender age, it is very difficult, or in some instances, that criminal record may never be done away with. Even if they outgrow the behavior, the bad behavior, and maybe would want to become law-abiding citizens and would want to secure employment in government or in the public sector, they will not be able to be employed in the public sector because they have that criminal record hovering over their heads. So we are saying children should not acquire criminal records at such a tender age, so that we give them time to reform and to be rehabilitated, so that they become lawful abiding citizens. Then it was also a strategy to decongest our prisons, because one of the biggest cost drivers in our Ministry of Justice was the prisons budget. So as a way of trying to decongest our prisons, we felt that maybe children that commit minor petty offenses should actually be diverted from the formal criminal justice system, so that the prisons only accommodate those people that deserve to be there, and those people that may be adults and not children. Then on the historical background of the pretrial diversion program, the government of Zimbabwe first accepted a proposal for the PTD program in 2009. However, the program only came into being in 2013. Then to enable more efficient and effective service delivery, the government of Zimbabwe, together with its partners, UNICEF and Save the Children, officially launched the program in June 2013 under the Ministry of Justice, Legal and Parliamentary Affairs. This is when the pilot phase was launched, introduced and launched. The pilot phase is when we were actually trying to test and see how the program will actually work in as far as rehabilitating children that come into conflict with the law. So the program was piloted in 5 districts, which included 4 urban districts and 1 rural district, so as to get the rural perspective of things. At the lapse of the pilot phase in 2016, the government of Zimbabwe took over the running of the program, both in terms of human resources and financial resources. So currently the program is now fully under government. We actually have a budget under the government budget, and we receive resources from government. So government is fully in support of the program, and they try by all means to ensure that all the program's activities are fully funded. At the lapse of the pilot phase in 2016, sorry, I've repeated that one. 2017 to 2019, we began work on the expansion of the program to other areas with the help from UNICEF. I indicated earlier on that in June 2013, that's when we launched the pilot phase. So the pilot phase came to an end in 2016. And then one of the recommendations that came out of the end of pilot phase evaluation was the need to scale up the program so that at least every district in Zimbabwe, every child in Zimbabwe is accorded an equal chance before the law, whereby the program is actually decentralized to various districts. So we began working on the rollout agenda, and initially we were targeting the main provincial capitals, whereby we're expanding to provincial capitals. We've got 10 provinces in Zimbabwe, and we will try to ensure that at least every province is covered in terms of implementation of the program. And then as we're going further, we're then focusing on the other districts that fall under the provinces. And currently we are now operating in 33 districts in Zimbabwe, and we continue to work on the decentralization program so that all districts are covered and children who commit minor offenses are accorded an equal chance. Then the objectives of the pretrial diversion program. The first objective was to make children who have come in conflict with the law to be more responsible and accountable for their actions. So we are not treating these children with kids' gloves, or we are not letting them off lightly, but we are trying to make them responsible and accountable for their actions so that at least they have a change of mindset whereby they actually realize the impact or the effect of their wrongdoing, and also they're able to change their behaviors. Then to open the judicial process for educational and rehabilitative procedures to come into play for the benefit of all parties affected by the offense. By this, I mean to say that traditionally we had other methods of dealing with crime and criminality, which were said to be retributive and punitive. But now we are saying, let's bring in educational and rehabilitative procedures so that at least this can actually promote the dignity and well-being of the child, the development of his or her sense of wealth, and the ability to contribute positively to society. Where appropriate, we encourage restoration, restitution, or compensation to the victim and thereby bringing closure to both the victim and the offender. Under the beauty about pretrial diversion is that there's a win-win situation. We try and bring a balance between the wrongdoer and the one that has been wronged. So it's in line with our African way of African traditional way of dealing with crime, whereby we promoted restoration of the societal fabric. We try to wrong the harm that has been caused by the offense committed by the child. So we bring the parties together, and then we negotiate for a win-win situation. Then to promote forgiveness of the child for the crimes committed, reconcile the child with the victim and the community, and promote and support rehabilitation and reintegration of the child offender back into the community. Then eligibility criteria. By this, I'm talking about who qualifies for pretrial diversion. These are children below the age of 18. According to our constitution in Zimbabwe, a child is a person who is below the age of 18. So what we are saying is a person who is below the age of 18 who has committed a non-serious offense. By non-serious offenses, I'm including offenses such as theft, unlawful entry, criminal nuisance. Those are the offenses that we are referring to. These are offenses that would usually attract a jail term of less than 12 months if the child was to be sent to prison. Then the child should be able to accept responsibility for the offense without coercion. They must preferably be a first-time offender, and they should be willing to take part in a program of activities identified by the diversion officer. Principles of the PTD program. The principles that we are looking at here include the best interest of the young person to be of paramount consideration. Contact with the formal justice system is to be minimized. The young person's right to protection from abuse, exploitation to be respected at all times. All children to be separated from alleged and convicted adult offenders. A young person's right to due process is to be respected at all times. Boys and girls are to be treated differently when necessary. For example, alleged girl offenders should be addressed by female officers and other justice professionals. Detention should be resorted to only where the young person is a danger to himself or where such detention is necessary in terms of Section 84 of the Children's Act. So basically, these are the principles that guide the officers whilst they'll be conducting themselves, conducting their duties. So as they are conducting their duties, the officers should be cognizant of these guiding principles, which are in line with international and regional legal frameworks. Then PTD measures currently in place. We have quite a number.
Kindly wind up. Time is not on our side.
Okay, we have a basket of options that we use when implementing pretrial diversion, and these are basically mostly the community-based measures whereby the child might be requested to pay reparation, make constructive use of leisure time. They could actually be requested to attend a victim offender mediation meeting, family group conferencing, and also attendance at a vocational institution. The basket is quite wide on the options that we use because these are community-based interventions. So depending on the nature of the community setup, we will actually come up with an intervention measure which is relevant to that particular community or society. Then the role players and stakeholders of PTD. In the implementation of pretrial diversion, we don't work in isolation. We work with other stakeholders who actually assist us in the implementation of the program, like civic society organizations. We work very closely with the Ministry of Public Service, Labor and Social Welfare, the Zimbabwe Republic Police, National Prosecuting Authority, and also the Judicial Service Commission. Then the community also has a very big role to play in this program. This includes the traditional leaders, church leaders, and the elders, as well as the ordinary people. They are involved in some of the diversion options as victim offender mediation, as well as reintegration of juvenile offenders. Then I've also come up with statistics on pretrial diversion on the figures, the number of children that have been diverted so far. The statistics that I've shared with you are statistics from 2016 to 2019 when the program was fully launched after the pilot phase. So from 2016 to 2019, we've managed to divert about 2,854 of the 3,314 that were referred to us. Our diversion rate is at 86%. Then I've also shared those statistics on the number of children. For both girls and boys and girls, the 15 to 17 age group was the most delinquent age group, owing to an increased number of vulnerabilities. Theft constituted the larger percentage of the offenses committed by children. And the types of offenses committed by children in Zimbabwe corresponds to other studies on criminal offending that the majority are minor, non-violent, and related to poverty as well as social learning. The best practice so far, we realized that what has made our program a huge success is the effective networking and coordination among key stakeholders. It is very important to work closely with other stakeholders involved in child care programs, because as long as they are not involved, we may face challenges in terms of fully and effectively rehabilitating children in conflict with the law. So it is very important to maintain a close network amongst all stakeholders involved in child protection. Then coordination and harmonization of services is the best option towards child protection, as well as ensuring children's access to justice is upheld. The introduction of restorative justice principles in our justice system and the development of a Child Justice Act is a crucial step towards the full realization of access to a child-friendly justice system in Zimbabwe. And then on the way forward, we intend to decentralize the program to even to the most remote districts in Zimbabwe, where we have the most vulnerable and marginalized children. We have 19 districts remaining under the rollout agenda. Then capacitation of all centers with the necessary tools of trade so that the program provides efficient and effective service delivery. Advocate for the inclusion of all offenses under PTD, because some offenses are viewed as serious, and yet there are extenuating circumstances that force the children to commit offenses. We intend also to have.
Madam, please wind up, and in doing so, please slow down so that they can hear you, but wind up, time is not on your side. Thank you.
It's okay, ma'am. Then there's need for more vigorous and extensive awareness campaigns to educate the public on the long-term benefits of having a pretrial diversion program. We also intend to have an aftercare program that supports program beneficiaries so as to reduce recidivism. I thank you very much for listening. I wish you a happy day of the African child, and wish you fruitful deliberations. Thank you.
Thank you, Madam Sandra. Thank you for sharing with us your comprehensive presentation on just a pre-trial diversion in Zimbabwe. I'm sorry I kept on interrupting you because time is not on our side. I'm going to now invite Mr. Rudolph So and Madame Auriel Schlick to present or discuss children deprived of liberties in Cameroon. Over to you, dearest panelists. Thank you.
Thank you, Madam. Good morning, Excellencies, ladies and gentlemen. I'm Madam Schlick Aurélie. I'm the one talking. Mr. So and I prepared the presentation, and I don't know whether my presentation will be seen by everyone there. But by the way, I can still make it even if you cannot project my presentation, which is in English there, but I will continue in French if you don't mind. Alors, merci de me permettre de présenter l'ensemble des mesures protectives contre la détention des mineurs. Et pour l'essentiel, ces mesures sont contenues dans 3 instruments juridiques nationaux, le Code de procédure pénale, le décret de 1992 portant régime pénitentiaire et le Code pénal, notamment ses articles 80 et 87, qui reprennent l'ensemble des instruments juridiques que le Cameroun a ratifiés, pour l'essentiel, la Convention sur les droits de l'enfant et la Charte africaine pour les droits et le bien-être de l'enfant. Alors, de manière spécifique, s'agissant du traitement de l'administration de la justice pour les mineurs, il y a des considérations générales qui commandent qu'il y ait une information judiciaire, l'information judiciaire. Allô? L'information judiciaire permet de mieux cerner la personnalité du mineur. Hello? Hello? Hello?
We can hear you. Can you put your presentation on the screen?
Am I the one? Okay.
We see you and we don't see the presentation.
La présentation n'est pas affichée sur l'écran. La présentation n'est pas affichée. Non, non, elle n'est pas affichée, non, pas du tout.
OK, là maintenant c'est affiché en fait.
Voilà, c'est bien, c'est affiché.
D'accord. Alors, je disais que la présentation, vous la verrez en anglais, mais je parlerai en français. J'étais déjà à mon deuxième slide. Allô?
Go ahead, we hear you.
OK. Alors, l'information judiciaire qui est obligatoire, qui est nécessaire pour connaître la personnalité du mineur. Ensuite, il y a la composition spéciale du tribunal, le Cameroun n'ayant pas les tribunaux pour enfants, mais des tribunaux de droit commun qui ont une composition spéciale lorsqu'ils connaissent des affaires qui concernent les enfants. Et cette composition spéciale, donc, comprend des assesseurs. Les assesseurs sont des spécialistes.
Non, spécial à la quatrième chambre, au niveau de la cour d'appel. Pas une chose, au niveau de la cour d'appel.
Les assesseurs sont des personnalités ayant une compétence en matière de droits de l'enfant et ces assesseurs envoient des délibératifs sur les peines et les mesures applicables aux mineurs. Par ailleurs, s'agissant de la compétence du tribunal, vous verrez qu'à côté de la triple compétence en matière criminelle, c'est ajouté la compétence du tribunal du lieu où le mineur a été placé de manière permanente ou provisoire, à côté évidemment des traditionnels lieux de compétence du tribunal. Donc, il y a le lieu de commission de l'offense, le lieu de domicile et le lieu où la personne qui a violé la loi a été trouvée. Une autre spécification est donc l'ensemble des mesures d'investigation que le juge peut ordonner pour mieux connaître le mineur. De ce point de vue-là, vous avez donc l'enquête sociale. Prochaine slide, s'il vous plaît. Oui, l'enquête sociale, l'examen médical, un examen psychiatrique. Nous avons donc des mesures alternatives à la détention qui consistent, entre autres, à des engagements que le mineur lui-même peut prendre pour se comporter bien et se présenter chaque fois qu'il sera requis. Cet engagement peut également être pris par un de ses parents ou par toute personne de bonne moralité qui peut s'engager à présenter le mineur chaque fois qu'il sera requis devant le tribunal. Prochain slide. Le mineur, notamment, doit être, lorsqu'il est privé de liberté, doit être dans un centre spécialisé. Et au Cameroun, nous avons 7 centres de rééducation pour les mineurs. Et les statistiques de juin 2020, il y a une petite erreur là, montrent que 130 mineurs sont placés dans ces institutions. Mais de manière générale, on a près de 900 mineurs qui sont dans les prisons. Alors, le décalage que vous observerez en réalité se justifie parce que ces centres ne sont pas équitablement répartis sur l'ensemble du territoire national. Enfin, il faut le préciser parce que c'est important. Sous peine de nullité, toutes les affaires où les mineurs sont impliqués doivent être débattues à huis clos. Alors, on va aller de manière spécifique à l'enquête lors de l'enquête policière. À cette étape de la procédure, il faut le dire, il n'y a pas de dispositions spécifiques de protection du mineur. Les mêmes dispositions qui s'appliquent aux majeurs s'appliquent aux mineurs, notamment le délai de garde à vue qui est de 48 heures. Prochain slide. 48 heures renouvelable une fois. Et cette durée peut également, cette garde à vue peut être renouvelée 2 fois de manière exceptionnelle sous autorisation du procureur de la République, autorisation écrite. Et cette autorisation doit spécialement dire pourquoi est-ce qu'on doit faire lieu à la prorogation. Prochain slide. Le mineur, durant ce qu'il est convenu d'appeler l'information judiciaire, peut faire l'objet de mesures restrictives de liberté, notamment une détention provisoire. Prochain slide, s'il vous plaît. La détention provisoire est envisagée différemment selon l'âge du mineur. Le mineur de 12 à 14 ans peut faire l'objet de détention provisoire uniquement en cas d'assassinat, en cas de meurtre et de coup mortel. Le mineur de 14 à 18 ans peut faire l'objet de détention provisoire lorsque cela est indispensable. Prochain slide. Toujours au niveau de l'information, judiciaire qui peut être faite, il faut dire que le mineur doit être détenu dans des centres spéciaux ou alors dans une section spéciale de la prison. En l'absence de centres spéciaux qui sont généralement les centres de rééducation, le mineur peut être détenu dans une prison pour adultes, mais il doit obligatoirement être séparé des adultes. Pour revenir encore à la phase de Pour revenir encore à la phase de l'information judiciaire, il y a un ensemble de mesures que le juge peut prendre. Il peut remettre le mineur à ses parents. Il peut également ordonner sa garde. Les mesures de garde visent à faire en sorte que le mineur s'abstienne de partir à certains endroits pendant la durée de la garde. Le mineur peut également être placé dans un centre professionnel, dans une institution spécialisée. Évidemment que le placement des mineurs dans ces institutions-là doit énumérer les raisons pour lesquelles le mineur est placé et énumérer la durée de la mesure prise. Il faut souligner que le placement du mineur ne peut se faire qu'à la suite d'un rapport d'enquête sociale et que les mesures de placement doivent être faites dans l'intérêt supérieur du mineur. Pendant la phase de jugement, le mineur est obligatoirement assisté d'un avocat et lorsqu'il n'en a pas un, le tribunal lui en commet un d'office. Le travailleur social est présent, les parents peuvent être là, le président du tribunal explique dans un langage qui est simple au mineur la substance même des faits qui lui sont reprochés et il peut ordonner que le mineur se retire de la salle pour ne pas écouter certains propos. Il peut également ordonner que certaines associations de défense des droits des enfants soient admises, malgré que le jugement des mineurs ne peut se faire qu'à huis clos. Alors, maintenant, lorsque le mineur est définitivement, du moins, lorsque le mineur est condamné, il y a un ensemble de mesures qui peuvent lui être appliquées. D'entrée de jeu, il faut dire que le mineur qui est âgé de 14 ans ou moins ne peut pas faire l'objet d'une peine d'emprisonnement. Alors, il ne peut qu'être placé, il peut être remis à ses parents, il peut être placé dans des centres, il peut également prendre un engagement de bien se comporter, sinon il va répondre s'il viole cet engagement-là. Et le mineur de plus de 14 ans et de 18 ans jusqu'à 18 ans peut faire l'objet d'une peine d'emprisonnement, mais cette peine d'emprisonnement sera prononcée en conformité avec les articles 80 et 87 du Code pénal. Les articles 80 et 87 du Code pénal qui disent que le mineur de cet âge-là, pénalement responsable, bénéficie de l'excuse atténuante de minorité. Et les conséquences de l'excuse atténuante de minorité, c'est que le mineur peut se retrouver en train de purger une peine qui est inférieure au minimum prévu par la loi et cette peine peut être réduite à 5 jours et l'amende à 1 franc CFA. Et chaque fois qu'il y a une mesure d'emprisonnement qui est prononcée contre le mineur, elle doit être assortie de la liberté surveillée. Et le mineur est généralement placé dans un institut jusqu'à sa majorité. Alors, à titre de bonne pratique, il faut relever que lors de l'enquête de police, il n'y a pas une disposition spéciale concernant le mineur, mais il faut dire que le ministère des Affaires sociales a fait en sorte qu'il y ait un travailleur social dès cette étape-là, et ce travailleur social accompagne le mineur en l'absence d'un avocat, en l'absence de toute disposition qui puisse être interprétée comme étant spécifique au mineur. Ce travailleur social peut venir d'une institution publique, mais il peut également venir d'une OSC, lorsque cette OSC comprend dans ses rangs des travailleurs sociaux dédiés à la cause des enfants. Voilà ce que je pouvais rapidement dire sur les mesures de protection contre la détention des mineurs dans mon pays. Si vous avez des questions, vous pouvez les poser en français ou en anglais. Mon collègue et moi, M. So, nous serions très, très honorés de répondre. Je vous remercie de votre attention.
Thank you very much, Madam Schlick. I'm sure we'll try and accommodate 1 or 2 questions at the end of our panel discussions. May I invite now the UNICEF team, comprising of Madam Henrietta Fore and Madam Eris Suzuki, to make
Hello?
Hello?
Yeah, excuse me.
Yes, Catherine?
Yeah.
Am I lost? Okay.
Okay.
Is there another presentation?
There'll be one presentation because the solidarity statement of Mrs. Henrietta Fore, the Executive Director at UNICEF, will not be done. She was not able to make it. So we only have the presentation by Miss Eri Mathers Suzuki. Thank you. Sorry for that.
Thank you, Catherine. I'm very sorry to the audience.
Excuse me. Excuse me. But okay, now she's on.
Hello.
We can't hear.
Can you hear me okay?
Yes.
Do you hear me okay? This is Ellie. So would you please take the presentation off, please, so that I can share my presentation on my screen? Madam Chair, do you hear me okay?
Yeah.
Okay. Actually, Madam Chair, I can't hear you. Is it only me?
Hello, can you hear me now?
Yes, I can hear you now very clearly. So are you hearing me okay?
Yeah, thank you very much. Please go ahead. Please
Okay.
proceed. Thanks.
Okay. So can you see my screen?
Certainly I can. Please go ahead.
Okay,
Yes, we can
great.
see your screen.
Okay. Hi, thank you very much for the introduction. My name is Eri Meides. I'm from the UNICEF. I'm OICing for the UNICEF child protection, so for the regional office for Eastern and Southern Africa region. So today, I'm given an opportunity to touch on child protection and the detention of children's issue. And so here, so I'd like to start with an overview. The deprivation of the children, liberty of children as a last resort is so one of the core beliefs UNICEF is promoting. And globally, so between 1.3 to 1.5 million children are estimated to be deprived of their liberty each year globally. So this is from the global study that was commissioned by UN General Assembly in 2019. So this number, as Mr. Ailiu presented, the deprivation of liberty is a broad concept that includes the civil administration and administrative detention. So this is the comprehensive figure. And so this one includes the children in institutions, also administrative justice, and also this includes the children who stay with their primary caregiver in prisons, and also immigration detention for the migrant children. Then I also would like to note, it doesn't include about 1 million children globally detained in the police custody. Unfortunately, we don't have the figure for the region, but this gives us a little bit of sense of how many children are detained in this region. By the way, this is very conservative estimate. So next, so UNICEF promote and work with the government. So two pillars. So to make sure children deprivation of the liberty of children, so to be the last resort. So one is alternative to detention and diversion mechanism. The alternative to detention is, I think we have so many legal experts, but it is about if it is pre-trial, making sure children have to be in detention, but to be able to stay with family. So bail system, bail sometimes have very big cost implication, but have it with conditions for children to be able to stay home. And it is after trial,
so alternative sentencing, so non-custody sentencing such as community services and probation. So this kind of like range of activities for the alternative detention. And the diversion mechanism is so conditional diversion of children from the so court procedures. And then Madame and Sandra so have just gave us very comprehensive view of the diversion mechanism in Zimbabwe. So I just like to present a couple of programs so UNICEF has been supporting the government. The first one, Morocco and Sudan. So both governments with support from UNICEF strengthen the normative framework and have done the capacity building so to promote non-residential alternative and diversion mechanism. So in Morocco in 2019, that resulted in 50% of children came in conflict with the justice system, with the law, was benefited from this system. And in Sudan, 1/3 of children in conflict with the law also benefited from that in 2019. Then in case of Sierra Leone, so it's also similar, very comprehensive diversion programs supported by the Ministry of Justice, led by the Ministry of Justice and other ministries. But one interesting thing was, so it has very clear linkage with the community mechanism for the mediation and also informal justice mechanism. So they have a strong chieftaincy system for the integration and rehabilitation of children. In 2019, so in our data system, at least 29,000 children were benefited from UNICEF-supported diversion order or alternative measure as opposed to a custodial sentence in Africa. This is also very conservative figure, so there should be many more children, but sometimes we have challenge in the data collection. So next, I'd like to touch on COVID-19. And in the past, depending on where, so we are part of the Africa, but in the past 3 months, 2 months, governments made such a huge effort so to ensure continuity of the justice services and legal services. So also from UNICEF, justice programming was an integrated part of the COVID-19 preparedness and response plan. And what I'd like to mention here is COVID-19 was an awful thing, but it's presenting us an unprecedented opportunity for us to build back better, so for the justice system for children. And in DRC, Republic of DRC, what has done, so UNICEF supported advocacy and financial technical support for children, so to be released from detention centers. So we also have supported transportation of also access to the social welfare centers for children. And so far 150 children were released. And I work for the Eastern and Southern Africa region. Then for the region I worked, I think probably more than several thousand children were released from detention centers. So in Malawi, so that's another aspect. So we work with the police, Malawi Police Services, so to develop a practical guidance note to ensure application of the existing diversion guidelines for the police and to also ensure child-friendly procedure. It's another angle, so not to just release children, but to make sure no new placement of children to occur. So in this COVID-19 situation. Then, and the third one, so if in Tunisia, so through the experience of COVID-19, also Tunisia so have done release of children, making sure so children can be away from the congested area so that they wouldn't be contact with the virus. Then the government took the lead so to take an opportunity so with the line ministry so to how they can find more better solution for the children in coming conflict with the law, taking this opportunity, and they are further strengthening the justice sector capacity and also the plan. It is one of the very strong examples. So COVID-19 so brought one opportunity so to further strengthening the justice system. So actually this is I ended my presentation, and thank you very much. And as I really mentioned, so we really hope so we can really utilize so this opportunity of COVID-19 so to make sure so for the justice services for children to be always considered to be essential services under whatever the circumstances, and also we can also be back better for the justice system for children. Thank you. Madam, unmute your microphone, please.
Hello, can you hear me now? Hello? Yes, I was just saying thank you very much for your presentation, Madam. And in particular, thank you very much for bringing COVID-19 into perspective with regard to children who are deprived of their liberties. It's a very interesting way of looking at it. Let me now give the floor to our presenter on practices in Africa, major challenges and proposed solutions for children deprived of liberties. I guess it's, according to the program, is Madame Doreen Nyamwalo Kazif from the Regional Program Office as a manager in Africa International Penal Reform International. Sorry about that. Regional Program Manager for Africa, Penal Reform International. Madame Doreen, may I give you the floor and thank you.
Thank you, Madam. Actually, I will be speaking on behalf of Ms. Doreen. I am Tagreed Jaber. I'm the Regional Director for the Middle East and North Africa. I hope that you can all hear me well. I have been asked to talk about the topic of children deprived of their liberties, the challenges and proposed solutions. Many of the points and aspects that I wanted to discuss in my presentation have already been highlighted by many of the colleagues who have spoken before me. But maybe I can give in a general overview some of the major and the main actually challenges that the justice for children or children deprived of their liberty face in Africa and also globally. The number one challenge, which was referred to by our colleague who spoke from UNICEF briefly and was highlighted by the United Nations Global Study on Children Deprived of Their Liberty, is the excessive use of detention. There's a major trend in all over the world, and Africa is not alone in terms of that, about really detention of children and the lack of use of alternative to imprisonment and other measures that can be used. So we're not really implementing the principle of detention as last resort in all of the judicial jurisdictions that we're having around the world, especially in Africa. The second challenge that we're facing is the low age of minimum criminal responsibility, which was highlighted also by one of the colleagues. While we're still witnessing in some of the African countries that we're having some countries that have the minimum age of criminal responsibility at 7. Sudan, Mauritania, Nigeria, Zimbabwe, and there's a need to work further on this issue to make sure that a child who is 7 years old is not really going through the criminal justice system with all of its complications and all of its problems. The third problem that we see as a major one that is widespread globally again and in Africa is keeping children in prison facilities. While in fact, it's true that these children are kept in special wings, but by the end of the day, these are prison facilities and prisons are not the place for children. Children should be kept in proper places that are called care centers that are not managed by the police or the military or any form of officers wearing uniforms. The other problem that we have is the poor, unfortunately, rehabilitation and reintegration programs. If we look at all children who are staying in detention, we will witness all across the globe, and mainly in Africa, a poor and weak rehabilitation programs that are targeting children, especially those ones who are centralized around the formal education. Many of the children who end up in detention, unfortunately, lose their right to pursue their education in a formal system. Add to that all the other reintegration programs. Some countries will have reintegration programs in place, but if we look at the percentage of children who are benefiting really from these rehabilitation programs, we will find out that the percentage is really very low. And this definitely will have a major impact on recidivism rates. And the fact that many of the children, I'll give you an example, I'm from Jordan, 78% of the children who leave juvenile centers in Jordan end up in prisons. So if we apply this principle or this study and we look at the situation in all of the other African countries, we will find out that many of the children who come in interaction with the justice system early and end up in detention, they will end up in detention as adults when they leave. The other thing which was highlighted also by the UNICEF colleague is the COVID-19. COVID-19 was a clear example for all of us to show us how the health services and sectors and protection inside detention is weak for adults and also for children. And this is one of the major challenges that we're having. Add to that the issue of mental health and how much we are paying really attention on mental health issues related to the children. The other main challenge that I see all across Africa and mainly also in some of the Arab countries and parts of the region is the poor or the lack of proper human rights-based approach programs and child-friendly programs that is focusing on dealing with violent extremism with the children and the rehabilitation of the children in this field and in this regard. These are some of the main challenges that we are having in that children who are deprived of their liberty are facing. We can talk about solutions, and I do believe that there's nothing is impossible and there's much to be done. And we have been introduced to some models from other colleagues who talked about specific programs that they are doing. The one and the most important aspect, if we would like really to work on solving the solutions of children deprived of their liberty, is to invest really in creating specialized justice system for children. And when I say specialized, I say a whole justice system chain that is only dealing with the children, taking their needs and their characteristics into consideration while they are going through the system. And this will start from the police level to the prosecution to the judiciary. A child-friendly justice system is the response to many of the issues that we have. We talked about the excessive use of detention. And this is mainly because of the mentality of those who are dealing with children within the justice system. The judges, the police, they see detention as the proper treatment for children. So we need to target behavior change. We need to focus more on training and capacity building for these individuals. The second solution that we're having and we're promoting is promoting early diversion. Children should not go through the criminal justice system when they commit minor offenses. They should be diverted to other programs that is focusing on correcting their behavior, more on a punitive system that aims at punishing these kids and these children. Alternative to detention is a need. There are some alternatives to detention that are there and available for children, but it's not enough. We need to invest further in this area of work and we need to expand it. And we need to focus also on the girl child when it comes to that and have a gender lens when we look at the appropriate alternative to imprisonment for children. Again, we need to start talking about taking children out of prisons and keeping them in care centers. Children should not be kept at prison facilities. Children should be kept in specialized institutions that are taking their needs into consideration. One of the other areas of investment that we should have is to develop proper rehabilitation programs that is really taking the formal education into consideration and that is really focusing on the market need. If our target is from rehabilitation, is the reintegration in the society, we need to enable these kids when they leave detention to be able to find proper job, to be able to survive in appropriate environment. And this will require linking the rehabilitation and reintegration programs to the marketplace, as is done in terms of the adults rehabilitation programs, which includes the vocational training programs. Add to that the mental health of children as a very important aspect of investing in terms of rehabilitation and reintegration program. It's timely, and it's not more timely than now to talk about upgrading health services for children. It's a very important issue. The principle of normality between the society and inside detention should be taken into consideration. And these children are the responsibilities of the state, and they should not be left behind. There should be a way of investing more in upgrading health services for children inside detention. COVID-19 was a harsh lesson learned for all of us, and I hope that we can take some of these lessons learned with us to expand our work as intellectuals interested in this field for the future. The last point that I would like to conclude with is to remind everybody of a very important category of children, the children who are staying with their mothers in detention. Those children did nothing except the fact that their luck was that they are born inside detention. It's a big number. There's around 19,000 child who is living with his mother inside detention, and they need special care. There's a need to invest more in their well-being, in their mental health, in their education, and they are in their early years exploring the world, and we need to invest more in that. With this, I end my note, and thank you for giving me the opportunity to participate. Thank you, Mrs. Chair.
Thank you very much, Madam Jaba. Thank you very much for sharing with us your presentation. We have had quite informative presentations, all the way talking about diversion, pre-trial diversion, through to protection of children throughout the trial, sentencing, and diversion measures. We also had our presentation on. Hello, can you hear me? Yes, I hope you can. Yeah, now following through all our presentation from UNICEF, with particular emphasis or reference to the gaps that have been highlighted by the COVID-19 and the last presentation that has actually shared us some of the weaknesses, the challenges that we are facing, the issues of overly use of detention, and or maybe excessive use of detention, and observations of lack of alternative measures. So with all these observations, with these experiences that have taken us across the continent, sharing with us our experiences in the continent, I want to say to everybody listening, all is not lost. We may be having challenges. We should also look at lessons learned and look for opportunities to improve on how we deal with children who have been deprived of their liberties. With this, may I see if there's any indication of somebody who wants to make a comment, one or two, before I hand over the floor back to the Director of Ceremonies for the day. Madam Catherine, may I thank the panelists sincerely for their informative presentation. I am sure that you are going to create an opportunity to share all the presentations somehow online, and that we will use the presentations at committee level to actually look at how far we have come as a continent and what else needs to be done in ensuring that we create opportunities for increased access to child-friendly justice system in Africa. With that, may I thank all the panelists. And if we were in a round, we're not in a virtual sitting, I would be saying a round of applause to everybody. Thank you very much. Over to you, Catherine. Thank you.
Thank you very much, Honorable Nanike, for that wonderful moderation. And we'll be able to share the presentation.
Madam Catherine.
For now, we'll hand over to Honorable Kembo for the next panel. Over to you, Madam Kembo.
Yes, I hope you are hearing me. Yes, thank you, Catherine, for giving me the floor.
Yes, we are hearing you.
I think Her Excellency, the Commissioner of Social Affairs, colleagues of the committee, representatives from member states, representatives of the UN agency.
We can't hear.
You can't hear. No, I'm just check. The mic is open. Are you hearing me?
Yes, I can hear you.
Okay, that's fine.
I can hear you.
Okay, thank you, thank you. So I was thanking Catherine for having
Excuse me,
given
Madam
me the
Kembo,
floor.
can you hear?
Yes.
Okay.
Are you hearing me, Catherine?
Now we can hear you. Thank you.
Okay. Thank you, thank you, thank you. I seize the opportunity to welcome everybody as we are moving to the third panel. We're having a look at the access to justice friendly courts and judicial proceedings, looking particularly at good practices and a limitation, because as you know, Violet said justice friendly system starts in the law, but we would not be considering just law in the books, but also law in action, particularly as we've started having an overview of the issues of detention. So now we're going to have a focus on good practices from different countries. We have actually 2 country experience that will be shared by 1 member of the judiciary, 1 member of the executive arm of the government, and we have been followed by an overview by a partner organization. So it's my pleasure and honor to invite the Honorable Lady Justice Martha Koome, Judge of the High Court of Kenya, to make the presentation on Kenya's experience in ensuring child participation in the justice system. Honorable Lady Justice Martha Koome, you have the floor.
Thank you very much, Madam Kembo, our moderator. Good afternoon, everybody, and good morning, depending on where you're watching from. Can you hear me?
Yes, I can hear you.
Okay. Thank you very much. It is indeed an honor for me to participate in this great convening with excellent presenters who are practitioners and experts in child law. I have learned a lot. Pardon? Yes, I've learned a lot from the many presentations. And I'm hoping that Kenya, which is constantly reviewing our laws and practices, will carry a lot of lessons from very good practices that I've had on how to ensure the best interest of the child is always protected. I used to serve at the committee between 2005 and 2010, and it is indeed
S'il vous plaît, veuillez fermer vos micros, s'il vous plaît.
Oh, sorry, I'm muted. Am I okay?
You may proceed.
Am I okay now?
Yes, yes, we are okay, Lady Justice. Can you proceed, please? I'm hearing you, Justice. Can you proceed? Hello?
Yes.
Hello?
Yes.
Yes, I'm hearing you. You
Am
can
I okay
proceed.
now?
Yes, you can proceed, Justice.
Okay, thank you very much. I'm sharing the experiences from Kenya on how children can access child-friendly justice. And I want to begin by saying that Kenya has domesticated the UNCLC and the African Charter and actually entrenched the fundamental rights of children in terms of defining the age of the child, which is 18 years, recognizing the family as the fundamental unit, recognizing that detention or deprivation of liberty of a child should be as a matter of the last resort, and dedicating a whole chapter in the Constitution on the fundamental rights of a child. We have also a Children Act, and I must say that it is under review, basically because of the age of criminal responsibility. As you have heard, Kenya is one of the countries with the lowest age of criminal responsibility, which is 8 years. And that is a matter of grave concern here to child rights defenders and the human rights institutions, including UNICEF. So we have reviewed the Children Act 2001 and a draft which has been completed that incorporates a higher number of years for criminal responsibility is waiting processes in Parliament. Another thing, another key area of concern that is included in the law review is diversion, which is not in the current law. And we believe it is going to solve the problem because once we did a research in our child-holding institutions for justice, it was discovered that 80% of the children held in child-holding institutions for justice did not have any reason to be there because they had not committed any offense known to law. So therefore, diversion is really recommended so that children can be sorted out at the community level and they can remain with their families. The Children Act also emphasizes that it actually domesticates the UNCLC and the African Charter, and it gives the government responsibility to take the maximum steps of its available resources to progressively realize the rights of children, which is basically to ensure the survival and the best interest of the child. The Act has a full chapter on children in the justice system. It requires that children should be tried in in a separate court, and the court should ensure that children are dealt with in an informal setting. In other words, we are supposed to have a building which is separate from the other court business dealing with children. You all know in Africa, we are limited by resources. We do not have many buildings and many magistrates who can be dedicated to deal with the children matters alone. That is a challenge that is shared across Africa, but I believe every country is innovative, and the innovation we have involved here in Kenya is ensuring that even if a court station, we have 130 of them spread all over the country, the 47 counties. Even if the court station is very small and the smallest has only 2 judicial officers, it is advised as a guideline to that court that they should reserve 1 or 2 days when they can deal with children matters, so that on those days, there are no other cases or other persons appearing in court, only children matters. Where the court stations are big, we have dedicated children courts just dealing with the children matters, trying to encourage judicial officers as much as possible to be sensitive about the children, to ensure their privacy and to ensure that their cases are handled expeditiously. We try to shield the identity of the child, and this is according to the law. The name of the child should not be disclosed. Their home, their last place of residence, or the school where the child goes should never be published in the judicial proceedings. And in all decisions regarding the upbringing of children, because we have been told children come to court in many ways. Some are victims of offenses, others come as witnesses, others are children in conflict with the law, others are in contact with the law, coming because of their parents or even to process their own papers one way or the other. So in all decisions regarding children, we are required by the law to avoid delay. To avoid delay that may prejudice the welfare of the child. Because if you delay a case of a child, the child may never get an opportunity to catch up with lost time. Courts are also encouraged to embrace video recording and closed-circuit video audio recording so that they can be shielded from the perpetrators of the crime, especially children who are victims. During this particular time of COVID-19 pandemic, we have experienced a spike in cases of child abuse, which is a matter of considerable concern because we have witnessed the worst forms of abuse against children, especially defilement cases have gone high. So we have called upon the police, even during this time of COVID, to ensure those cases are investigated and they are taken to court, even if they are scaled down court proceedings going on. The cases that are being given priority in Kenya are all cases involving children, so that orders, appropriate orders can be given to safeguard the interests of the children. We've also asked for a serious campaign to be carried in the communities to sensitize the parents about taking care of their children during this time and asking them the pertinent question of who is abusing children when they are supposed to be at home. I have to speak about participation of children as we talk about access to justice. Yes, I can hear you, Madam Moderator.
Okay, please, may I kindly request that you try to wrap up like in 2 minutes time.
2 minutes time, I'll wrap up because I'm talking about participation of children during court proceedings. It's also enshrined in the Constitution that you cannot make a decision about somebody without hearing them. So children, even if they are disadvantaged by their age, they should always be given an opportunity to be heard before a decision is made that affects them. As far as legal aid is concerned, it's also provided for in the Children Act that every child should be accorded legal aid. It is the responsibility of the magistrate to appoint a lawyer if a child appears in a court without legal representation. And what is emphasized is that children matters should be dealt expeditiously. As I close, I want to share with you what I call a best practice. That is a collaborative effort by the National Council on the Administration of Justice that put together a special task force on children matters to include all the stakeholders in the administration of justice. That is the judiciary, the police, the attorney general, the investigators, the office of the public prosecution, the human rights probation, director of children's services. All of them work together in a coordinated approach for each one of them to play their role, because no one institution can be able to attain the best interest of the child without the collaboration and support from the other agencies of the government. So this model has worked very well because they monitor the cases of children, not only at the headquarter level, but even at the court station. That body is replicated to ensure the best interest of the child. Thank you very much for giving me this opportunity. Thank you for the good work that has been done to set very high standards in Africa by creating instruments and guidelines. The work we have now is implementation, and this is good. We continue encouraging each other. Happy Day of the African Child, Africa Child Matter, Lives Matter. Thank you very much.
Thank you indeed, Honorable. You've said it all. Implementation is the key, and you've also outlined how issues of children are cross-cutting issues, needing our combined effort to tackle the different challenges. Maintenant, je voudrais passer la parole à Son Excellence, Madame la Ministre Diaby Sila Mariama, ministre de l'Action sociale, de la promotion féminine et de l'enfance de la République de Guinée, pour nous entretenir sur les mesures de protection des enfants dans les procédures pour mineurs en République de Guinée. Excellence, Madame la Ministre, vous avez la parole.
Merci pour la parole, Monsieur le Président de la Commission de l'Union africaine, chers homologues ministres, Mesdames et Messieurs les partenaires du système des Nations Unies et des institutions internationales, Mesdames et Messieurs les partenaires de la société civile, Mesdames et Messieurs les membres du Comité africain d'experts sur les droits et le bien-être de l'enfant, chers enfants de Guinée, d'Afrique et du monde, Mesdames et Messieurs. C'est un insigne honneur pour moi de prendre la parole en cette journée commémorative de la Journée de l'enfant africain au nom de mon pays et de la sous-région Afrique de l'Ouest. À cette occasion solennelle, j'adresse mes vives félicitations au Comité africain d'experts sur les droits et le bien-être de l'enfant pour son engagement continu en faveur de l'enfance africaine. La reproduction d'un État respectueux des droits humains sous-régional, régional et international en matière de protection des enfants. Au titre des réformes institutionnelles, plusieurs textes de loi en faveur des enfants ont été révisés. Il s'agit de la loi d'organisation judiciaire, le code de procédure pénale, le code pénal, la loi portant code de l'enfant. Tous ces instruments 5 dernières années. Cette réforme donc a favorisé la fluidité dans la gestion des affaires juridiques impliquant les enfants, mais aussi la mise en place des alternatives à la détention, comme la nomination des juges d'application des peines en vue de l'institution renforcer la protection des enfants. Distingués participants, mesdames et messieurs, s'agissant des procédures judiciaires relatives à la protection des enfants, nous enregistrons 3 étapes en Guinée. La première étape, c'est l'enquête préliminaire qui se fait au niveau des postes de police par l'Office de protection du genre, des enfants et des mœurs et de gendarmerie à travers la division spéciale de la protection des personnes vulnérables. En deuxième phase, nous avons le ministère public ou le parquet. Ceci constitue un dossier spécial concernant les enfants et saisit les juridictions compétentes sur les questions de mineurs, en l'occurrence le juge des enfants, le tribunal pour enfants de Conakry, les sections pour mineurs et la chambre spéciale des mineurs des 2 cours d'appel en Guinée. Dans les modes de saisine du parquet, les procédures de flagrant délit et de citation. Troisième phase, c'est les sanctions applicables aux enfants lors du procès. Ceux de 13 ans bénéficient de droits et en cas de culpabilité de l'excuse absolutoire de eux ne peuvent faire l'objet que de mesures de protection, d'assistance, de surveillance. Pour la procédure civile, assistance éducative au niveau de la justice, elle est largement précisée dans les dispositions distinguées participants. S'agissant des mesures de protection sociale, il existe un mécanisme classique de protection à base communautaire tenant compte des dimensions formelles et informelles, ainsi que de l'interopérabilité entre les différents secteurs. Pour le cas spécifique des enfants en procédure pénale et civile, le mécanisme de prise en charge est composé des travailleurs sociaux de l'État et des ONG, des juges pour enfants, des agents de police et de gendarmerie et des centres d'accueil. Ce mécanisme participe à la médiation pénale auprès des juridictions pour enfants, l'accompagnement des mineurs bénéficiant de mesures à disposition dans les centres d'accueil, l'accueil temporaire, hébergement, soins alimentaires, soins vestimentaires, soins sanitaires, le retracement familial, facilitation à la conciliation sociale entre familles et parties civiles, l'écoute ou l'enquête sociale et le suivi et la réinsertion socio-éducative et professionnelle des enfants. Mesdames et messieurs, distingués participants, en cette année 30 de la Charte africaine des droits et du bien-être de l'enfant, il demeure plus que fondamental de réitérer le respect de nos engagements en faveur des enfants et de porter nos réflexions sur des mécanismes idoines de prévention. Il est aujourd'hui clairement démontré que ce n'est pas aux enfants de s'adapter à nos systèmes judiciaires, mais bien au système judiciaire de s'adapter à leurs besoins. Cependant, malgré les efforts consentis par le gouvernement guinéen sous l'impulsion de son Excellence, Monsieur le Président de la République, chef de l'État, le professeur Alpha Condé, et l'appui de nos partenaires impliqués dans la mesure dans la mise en œuvre de la Charte africaine des droits et du bien-être de l'enfant, il reste beaucoup de défis à relever pour la mise en place effective d'un environnement juridique fondamental. Je termine par réitérer de nouveau la ferme conviction de mon pays de parvenir à la construction d'un monde meilleur pour les enfants. Vive les enfants du monde, d'Afrique et de la Guinée. Je vous remercie.
Merci, Madame la Ministre, pour cette présentation assez exhaustive, synthétique de ce qui se passe en Guinée à travers les institutions spéciales, les mesures de protection spéciales, avec une emphase particulière, n'est-ce pas, sur l'option de conciliation et de réhabilitation qui est la vôtre en République de Guinée. After hearing from Guinea's experience, we'll move forward to have an overview by a partner organization. States are working. You had an overview by a member of the judiciary. You have a member of the executive arm of government speaking. Now you are watching. You are also helping as a civil society organization. So what have you to say? We need to hear you on that. And I will kindly invite Mr. Cleophas Maragia, who is the Child Rights Advocacy Advisor at Save the Children International at the AU Liaison Office and Pan-African Office. Cleophas, you have the floor.
Okay, thank you very much. Thank you to the speakers that have spoken before me, and I hope you can all hear me. We have 7 minutes. To be honest, it's quite a lot to go through in 7 minutes, talking about the various challenges that we have on the continent in regard to the theme of this year's Day of the African Child. But I will try to use the 7 minutes as judiciously as possible. And maybe to start with, I was privileged yesterday to attend a children's consultation regarding the theme of this year's Day of the African Child. And I'm very happy to see that a lot of the issues that they raised yesterday are being addressed. They are coming up in the discussions. And that is a very positive thing because they may have spoken it in a different language, definitely less complex than we are doing right now. But the issues that they raised are coming up and they're issues that we need to deal with in due course. Secondly, in the current context of COVID-19, as the previous speakers have alluded to, the issue of child-friendly justice system becomes more crucial because we are seeing increased violations against children, first of all. There are many factors that are leading to this, but we are seeing more violations against children. But also we are having more children coming into conflict with the law because due to various issues like the lack of social protection at country level, high poverty levels, we have a higher number of children coming into contact with the law, which means then that if we don't have a child-friendly justice system, then we have a big crisis ahead. The generation that we are working towards ensuring that they have a better future, there will be a crisis ahead if we don't have a proper justice system. My work is essentially to do a wrap-up of what the two previous speakers have said and try to see continentally what are some of the good practices, what are some of the challenges that we are facing. And from where I sit, we first need to acknowledge that very few children on the continent enjoy the rights that have been articulated in the African Charter and the CRC. The Charter, the CRC, they are very clear, and as Honorable Martha Koome pointed out, it's the implementation that we are looking at. That is where the problem is. But the Charter is turning 30 this year. We should be asking ourselves if we are still implementing aspects of this Charter at national level for 30 years, then will we really ever get to the point where we wanted to be? So first of all, we need to acknowledge that few children enjoy those rights. Children also face persistent barriers to the fulfillment of their rights in the justice system. Even for an adult, the legal system itself is a long, confusing, nightmare kind of encounter in many countries. And we often struggle a lot with it. So you can imagine how this is for a child, a 13-year-old, a 14-year-old, how difficult it is if we don't make our justice system friendly. There is also the risk of victimizing children a second time. This is especially when offenses have been committed against them. And since our justice system is not child-friendly, we end up making them victims again. So we need to look at this. Even if we have all these best practices, I believe we can do better. And maybe from the previous speakers, right from the introduction to the first panel to the second panel, there are various levels. We are looking at pre-trial, we are looking at trial, we are looking at post-trial, and there are various challenges and best practices that come along all those stages. So first of all, in terms of access, Honorable Kwame pointed out that we have a resource problem on the continent. We have a resource problem in that we have many competing priorities for national budgets. And in all honesty, the justice system always does not score among, let's say, the top 3 or the top 2. So we have a resource problem, but in some countries, they have been very creative and innovative in that we have things like mobile courts to make sure that children in rural areas are reached, children in hard to reach places are reached, children in all these other places where we don't have the infrastructure. She talked about dedicating days to make sure that children's issues are heard, just to ensure that these processes are followed. And for me, the recommendation there is, it's not all about going all out and establishing the infrastructure, but once the spirit is there that children's issues need to be dealt with separately, and this is going to ensure that they access justice, then that marks a beginning. That gives a starting point where we are able to address this issue. So countries, for example, in Kenya, have approaches where we have mobile courts, we have specialized children's courts, and I think many countries should emulate this and ensure that we don't lump in children's issues together with everybody else. So that's number one. And the second aspect of, yes?
Are you getting me?
Yes, I'm getting you.
Okay, please try to wrap up like in 1 minute time, please.
Okay, the second issue that I will talk about is the issue of legal aid as well. We know due to resource challenges, many children are not able to access legal aid. They are not able to access lawyers. In many countries, in some countries actually, there are provisions to ensure that children are able to access legal aid. And this is something that is commendable because it ensures that the process of children's issues being heard is done in a proper manner. And the one thing maybe I would like to point out that is very important as I try to wrap up is the issue of confidentiality. When we want children to participate in judicial proceedings, we need to make sure that we safeguard their confidentiality, because children end up being victimized again when the information about their cases, when they are able to confront their accusers in court and people gain information about them. And in some countries, there are very clear regulations about how you can handle information pertaining to children, how children's cases can be listened to, in what environment. And I would like to encourage other countries to actually take it up from there, because children are already exposed, they are already vulnerable, and it's important to have these additional safeguarding measures in place. So as I wrap up, there are a couple of recommendations, but most of them are still going to come out when children make their presentations today. The one I would like maybe to point out is the need for various justice systems to take into account the needs of children with special vulnerabilities. We are talking about refugee children, we are talking about children with disabilities. Many a time, these children don't get to experience the same level of protection as other children due to various reasons, and they are the ones who need it the most. So we need to make sure that children are protected. Yes.
Yes, I think there is a dedicated panel for vulnerable children, which comes just after you play. I kindly ask that you may allow us to dedicate a particular discussion, extensive discussion on that. Thank you.
Okay, thank you. So maybe as my last sentence in regard to this particular issue, it's also about ensuring that we treat children with dignity and fairness that they deserve. In many cases, we see children who are in contact with the law being treated negatively by parents, caregivers, even teachers, and this affects them negatively. And as I indicated already, it affects them for a much longer period. And with that, I would like to say thank you to the two panelists, and we will be addressing this issue as we go further with the discussions. Thank you.
Oh, thank you, Cleophas. I'm grateful for these comprehensive presentations, spotlighting what are our challenges in taking care of our children. So we appreciated the two country presentation, also appreciating you as a partner of pinpointing what are the challenges that we still need to tackle. With that, I think we need to wrap up this panel. Thank you for your wonderful presentation. And we will proceed without further ado. We proceed to the fourth panel. And the fourth panel will be spotlighting the invisible, as Dr. Violet pointed it earlier. We'll have an overview by still our partners organization. We have an overview by the Plan International, and we also have an overview with Vision International. As you know, children, we cannot take children as a bulk. We need to tailor specific solution for children in specific situation. So for that, I'll kindly ask Mr. Samuel Norga, Director of Plan International AU Liaison Office, to present us his paper on barriers to access to justice for the girl child, norms and practice in Africa. Sam, you have the floor. Can you get me Sam? Someone? Someone?
Hi.
Okay, hi Sam, you have the floor. Thank you.
Yes, okay, can you hear me?
Yes, I can hear you.
Okay, thank you very much. I think I would want to use the opportunity to congratulate the committee and also the Department of Social Affairs for commemorating the Day of the African Child. And Plan is very happy to be part of this important celebration. And especially, I would also want to pay tribute to all girls and children who have fallen victims to the justice system that are supposed to be protecting them, but unfortunately are not guaranteeing and not safeguarding their rights, whether they are victims, witnesses, or offenders. I think it's also important to note that the theme for this year comes at the heels of the 30th anniversary celebration of the African Charter on the Right and Welfare of the Child. And there's no better way of celebrating the Charter than to look at the very fundamental rights which defines the environment within girls need to enjoy their fundamental rights and their freedoms. But unfortunately, we are also celebrating this day and discussing these issues at a time where we are at the heat of a pandemic, which seems to be reversing the progress we've made and the gains we've made in our agenda work. So that is a bit unfortunate. But I think, as Catherine said in the beginning, we would want to take advantage of the situation and use our lemons to prepare lemonade, and that is take advantage of the situation we have to also bring the issue of access to child justice for girls to the fore. Now, I would want to also indicate that justice has a gender face and has a gender dimension, and that is why it's important to discuss the barriers to access to justice for girls. But sometimes we do lump boys and girls together, and sometimes we do forget the gender dimensions of the issues facing children. And so I think it's very important to highlight that justice has a gender dimension, and that is very important to raise in every discussion. I mean, as Cleophas said just not too long ago, Now, it's important to know that the challenges that girls go through as a result of delayed justice processes set them back many years and sometimes leave an indelible pain which they have to live forever in their lives, and especially if it has anything to do with sexual offenses, sexual harassment and abuses. They live with those pains for the rest of their lives. Now, the barriers to gender-based, child-friendly justice for girls is systematic, it's systemic, it's structural, and it's also well documented. We all know about them. They are discussed in various forums. And I think when the girls were discussing the barriers yesterday, they were exactly talking about the barriers they go through. So I would want to quickly go through the barriers and also recognize that we have an opportunity to redress some of the barriers that the girls discuss. So the first one is definitely around COVID-19 and its restrictions. Because of the restrictions, because of the lockdown, I think the Lady Justice mentioned the surge in incidences of child abuse cases and sexual offenses. And that is because children are home, girls are home, and they are normally at the tail end of receiving such practices, such unfortunate practices. And because of COVID, you can't even travel to go do the report because you've been locked down. But also there are other challenges and barriers around physical access. Now, we're talking about children in remote areas. We're talking about children in communities where it's difficult to reach. And if something happens, if an offense is committed against them, and they'll need to be able to approach the police. Now, the point is that it takes time for them to get to the nearest police station or to get to the nearest court. And so that in itself prevents a lot of girls from accessing justice. But it also denies millions of girls who live in those rural areas to be able to access justice. The other challenge and barrier is around institutional arrangements and the setup of our justice system. We all know that most of the personnel who are within the justice system are male-dominated, and sometimes very unfriendly, policemen or prosecutors. And so it makes it very difficult for girls to be able to go report cases. And sometimes they get being intimidated when they report those cases. Our court setup, I think have been said already, are not always friendly for children, let alone for girls to be able to go and report cases. And again, we also have challenges with language. Sometimes we don't have the right people in court to interpret, not being in a court situation where the interpreter was saying something very different from what the person was saying. So sometimes those pose challenges. And in addition to that, we also have very long court proceedings. And I think the Lady Justice mentioned that time doesn't wait for children. I mean, at the age of 17, if a case is delayed up to 18, they are no longer children. And so they miss that opportunity. We also have seen documented cases of sexual abuse and other forms of harassment against girls who go to report cases at the police station. The other challenge barrier I would want to talk about is financial implications and the challenges. Now, I think we all have to accept, and I think even mentioned, that justice is sometimes sold to the highest bidder, and especially in cases where girls are involved with people who are well-to-do in the community. They buy out justice, they prevent girls from getting their case out. But sometimes it's also the fact that they don't have access to legal counsel, and because the services for lawyers are very expensive, they are not able to access legal services. Now, poverty definitely is a big driver and which also result in most families dropping cases because they cannot follow through with the case. And so that is a big barrier to girls accessing justice. The other barrier, which is also very critical, is the plural legal system we have. And I think that was mentioned earlier by Yalo also.
Samuel, are you hearing me?
I'm hearing you.
Okay, thank you. I will please, we will be pleased if you can wrap up in 1 minute, please.
Okay. So a few recommendations. I think the first recommendation is that we need gender responsive approaches to the justice system. We need girl-friendly spaces for girls to be able to speak out and also speak in ways that do not intimidate them. We need provision and establishment of child-friendly courts in line with the General Comment 5 of the committee. And we need to continuously build the capacity for people involved in the legal system, our police, our prosecutors, our lawyers, and our judges. We need to involve girls in the review, planning, implementation of girl-friendly justice system. And as somebody said, we definitely have to resource the legal systems, but also we need to review the criminal responsibility ages, which in some countries is as low as 7. Now, quickly to say that plan is working to support the training of paralegals in countries. We are working and supporting child helplines for girls to be able to access and be able to report cases. We are providing legal case and legal aid wherever is possible, and also advocating for girl-friendly justice systems, and that is exactly what I'm doing now. Finally, I would want to say that the right to child-friendly justice system cannot be divorced from the very fundamental rights of girls. And for Africa to achieve the aspirations in Agenda 2040 and 2060, we need to build strong, accessible, and gender-responsive justice system that is friendly to girls and which addresses their specific needs. Thank you very much, and I hope to be able to engage much further in the Q&A.
Thank you, Samuel. Thank you for the wonderful job of Plan International and its endeavor on that. In that regard, I think you've pointed out the gender dimension of justice. I think for you, to the question, where if you put the question, does it matter that the judge or the prosecutor is a male or is a man or a woman? You say overwhelmingly that yes, it does matter. It does matter also that we take into consideration the context, and as presently we are in a difficult situation due to the outbreak of COVID-19 pandemic, which has come to add to the previously existing challenges. So it comes with challenges, but also it comes with opportunity of righting the wrongs. So I would like to invite Mrs. Vianne Ndong from World Vision International at the Saro Regional Advocacy. She's the Saro Regional Advocacy Director. Please, Mrs. Ndong, could you kindly entertain us on access to justice for children during this COVID pandemic, outlining the challenges and good practices? You have the floor, please. Do we have Mrs. Ndong? Are you getting me, please? Are you getting me? Hello?
Yes,
Yes, we can hear you.
We're getting you.
Okay, thank you. I was kindly inviting Mrs. Ndong from the World Vision International to give her presentation on access to justice for children during this COVID-19 pandemic, outlining challenges and good practices. You have the floor. The presentation is on the board, but we can't hear you. Are you ready? Can we have the sound, please? Yes, can you go on, please?
No.
Please, I think we have a technical challenge. Can we have Mrs. Ndong, please? Your presentation is on. You can go on, please. We are visualizing your presentation. Now we need the sound. You need to hear your voice, please.
Maybe she can try without the...
It is okay. It is okay now. We are hearing somebody. Hello, Mrs. Ndong? Can you proceed, please?
Can you unmute her mic?
Okay.
Maybe with...
It is okay. We are getting you. You can go on, please.
Dim, vianney barikiwa yalla nako.
Hello? Hello? Mrs. Ndong, you have your presentation. We are visualizing it. Please kindly go on with the presentation.
Madame Vianney, essayez d'enlever vos écouteurs et puis parler directement comme ça. Peut-être que c'est ça qui fait que ça ne marche pas. Essayez d'enlever vos écouteurs.
Est-ce que vous m'entendez maintenant?
Oui, on vous entend, s'il vous plaît. Est-ce que vous pouvez y aller?
Ah, ok, merci beaucoup et excusez-moi pour ces quelques dérangements de la technologie. J'étais en train de dire que je remerciais l'Union africaine au travers de son comité pour le bien-être des enfants et j'aimerais saisir cette opportunité aussi pour remercier tous les autres intervenants qui ont fait vraiment du bon travail et qui nous ont donné beaucoup d'informations. Comme je disais, nous avons 7 minutes et pendant ces 7 minutes, je vais essayer de mettre beaucoup plus d'accent sur les aspects des enfants les plus vulnérables dans ce grand thème que nous avons, l'accès à un système de justice adapté aux enfants en Afrique, et particulièrement pour ce panel où nous allons voir l'accès à la justice des enfants en situation de vulnérabilité avec un accent particulier sur COVID-19. Alors, j'aimerais d'entrer en jeu dire que quand nous sommes en train de rechercher la justice des enfants pour les enfants et en particulier pour les plus vulnérables, fait partie de notre mission, bien sûr, avec d'autres partenaires qui sont ici. Aussi faire participer les enfants comme une force essentielle de changement en renforçant leur participation, ça fait aussi partie de notre approche. Alors, je sais que déjà, avec mes prédécesseurs, Save the Children, Plan International et les autres, UNICEF, et même au niveau des avocats Zimbabwe et autres, ils avaient déjà tracé un peu le tableau par rapport à certaines bonnes pratiques qui existent dans le monde. Et nous disons que les conventions, effectivement, les déclarations et réglementations internationales et régionales contiennent des références portant sur les obligations des États d'offrir l'assistance juridique aux enfants. Nous savons aussi que la plupart des pays ont ratifié, cela a été dit, les différents instruments. Nous savons aussi que les pays, au niveau de chaque pays, il y a des dispositions légales qui existent. Mais ce que nous sommes en train de voir, les défis, on les a déjà dit, on a un nombre limité des tribunaux pour enfants qui permettent par l'enfant particulièrement vivant dans les milieux reculés. Quand nous parlons ici des enfants les plus vulnérables, nous regardons aux enfants qui vivent dans les camps des déplacés, les enfants qui vivent dans dans le camp dans les camps des réfugiés. Nous voyons les enfants qui sont, les filles qui sont handicapées ou même les garçons. Et tout cela constitue vraiment les caractéristiques des enfants les plus vulnérables. Et nous avons aussi une présence très limitée des établissements et nous avons aussi l'absence surtout des assistants sociaux qualifiés qui, pendant cette période de pandémie, deviennent très importants pour faire l'assistance et apporter un besoin impérieux aux enfants. Alors, dans le cadre de COVID-19, on l'a déjà dit, nous connaissons que les enfants sont confinés et pendant qu'ils sont confinés, ce n'est pas toutes les familles qui sont favorables, sont un milieu favorable aux enfants et nous nous retrouvons avec des auteurs des abus des enfants qui sont très proches de ces derniers et de ce fait, les enfants sont rendus au silence par les abuseurs. Et nous sommes aussi en train de voir les enfants qui ne sont pas accompagnés. Parmi les enfants les plus vulnérables, il y a les enfants qui ne sont pas accompagnés. Et ces enfants, quand il s'agit de procès, il s'agit de justice, ils n'ont même pas des parents présents. Et les personnels qui doivent les accompagner ne sont pas là. Alors, aujourd'hui, je veux plus parler sur un rapport que Vision Mondiale a publié qu'on appelle Aftershock et je vais partager le lien avec tout le monde qui est une tempête parfaite et nous savons que nous avons essayé de regarder quel est l'impact de COVID sur les enfants particulièrement. Nous avons vu que les enfants, les écoles sont fermées et nous voyons que la situation, excusez-moi un moment, les écoles sont fermées et les enfants se retrouvent en confinement et parfois ils sont confinés avec leur abuseur, j'étais en train de le dire. Nous reconnaissons aussi que les incidents de maltraitance et de violence ne peuvent qu'augmenter avec cette situation de COVID-19. Et je crois que mes prédécesseurs l'ont si bien dit aussi. Et ajouter, nous savons que toutes les fois qu'il y a des situations graves de vulnérabilité, nous avons par exemple le cas d'Ebola, nous avons le cas d'Ebola récemment d'ailleurs en RDC, vous allez comprendre que la situation et la sécurité des enfants deviennent de plus en plus très précaires. Alors, comment est-ce que nous allons avoir une justice dans cette situation où nous disons que 85 millions d'enfants supplémentaires pourraient souffrir? Et c'est pourquoi nous pensons que la meilleure façon de réclamer justice pour ces enfants, et surtout les enfants les plus vulnérables, c'est de regarder au système de protection des enfants. Dans cette même étude, on a vu par exemple au Bangladesh que la situation des parents, les parents qui sont en train d'exercer une violence sur leurs enfants, c'est passé à 42%. Et j'étais en train de lire un lien avec UNICEF qui a parlé qu'en Afrique du Sud, par exemple, en mars de cette année, le nombre d'appels passés à Childline, l'assistance téléphonique gratuite en Afrique du Sud, a augmenté de façon stupéfiante. Plus de 3000 appels par rapport à l'an dernier. Alors, nous parlons aussi des mariages précoces qui sont déjà, le nombre est déjà significatif en Afrique, mais qui vont encore augmenter. Nous nous référons à UNFPA qui avait déjà dit qu'à ce stade, à cette année, on aurait déjà 150 millions, mais nous pensons qu'il y aurait encore 13 millions qui vont s'ajouter. À part ça, nous avons aussi conduit notre recherche pour faire participer les enfants. Et je crois que les Cléophas de Save the Children l'a si bien dit. Nous avions parlé avec les gens au moment où on a fait la consultation des enfants avec la société civile, le forum de société civile au niveau austral. Et nous pensons qu'il y a perturbation scolaire, détresse émotionnelle, pauvreté croissante, et puis violence sexuelle. Et là, vous avez quelques citations des enfants, je ne vais pas en revenir, mais je voudrais juste parler d'une citation particulière où il y a un enfant de 17 ans en RDC qui dit « Nombreuses filles sont violées, des enfants kidnappés, d'autres recrutés pour être des rebelles, utilisés comme boucliers, espions, soit esclaves sexuels, les enfants sont exploités économiquement et c'est dans ce contexte que COVID-19 vient s'ajouter. Et si je rentre en arrière avec le tableau que tous les prédécesseurs nous ont peint par rapport à la situation de la justice, et surtout notre jeune délégué de la Zambie qui a commencé par dire que le système de la justice des enfants doit être accessible, rapide et adapté. Nous pensons que si nous devons faire justice aux enfants, il serait important que tous les parties prenantes regardent vraiment à faire de la protection de l'enfant une très grande priorité et de se rassurer que cette protection est intégrée dans tous les plans de réponse actuellement et surtout en considérant cette classe des minorités, la classe des plus vulnérables. Nous devons aussi nous rassurer que les mesures de protection sociale soient en place pour les plus vulnérables en fournissant particulièrement...
Madame Don.
Oui.
Madame Don. Vous m'entendez?
Oui, je vous entends.
D'accord. S'il vous plaît, est-ce que vous pouvez conclure dans 30 secondes, s'il vous plaît?
Oui, je suis en train de conclure. Donc, j'étais en train de dire que nous devons reconnaître les services de protection de l'enfance, par exemple les assistants sociaux, comme fonction essentielle. Vous savez, nous étions dans le confinement et la plupart des services ont été confinés et dans certains pays, on a même confiné les assistants sociaux, alors que ce sont des fonctions trop essentielles pour l'encadrement des enfants. Alors, pour conclure, pour terminer vraiment, j'aimerais dire que l'accès à la justice elle est très importante, mais elle est encore une source de préoccupation en Afrique. Et la meilleure façon de vraiment faire justice aux enfants pendant cette période, c'est de se rassurer que nous travaillons sur la prévention en considérant la protection des enfants comme étant très essentielle dans tout le travail que nous sommes en train de faire. Je vous remercie.
Amplifier non seulement les vulnérabilités, mais également les risques. Donc, de ce point de vue, il y a une urgence d'adapter les réponses dans le cadre du système de justice, non seulement en termes de procédures, de la façon dont les procédures sont diligentées, mais surtout également dans le cadre des prises en charge psychosociales qui sont offertes aux enfants. Je pense que c'est ce qu'il faudra retenir de ce panel spécifique sur les enfants vulnérables, sans oublier naturellement le focus qui a été fait sur l'aspect genre, la vulnérabilité particulière des filles qui a été mise en relief par plan international. Sur ce, je vais pouvoir conclure en remerciant à la fois Samuel Noga et Madame Veyanin Don d'avoir participé à cet important panel. Je vous remercie. Je voudrais demander maintenant aux participants du dernier panel de bien vouloir se préparer. I'm calling upon to the participants of the fifth panel, which is dedicated to the role of civil society, media and children in improving access to child-friendly justice system in Africa. It is often said, nothing for us without us. So we firstly hearing from a child, and then our child Abdile Mumin, who is the children representative from Kenya, will will give us a gist of what he thinks is the role of the children in ensuring access to justice system in Africa. Dear child, you have the floor. Thank you. Are we having our child representative for the fifth panel?
Hello?
Yes, hello.
Mumin Abdullah.
Okay, thank you. Welcome, Mumin. Welcome, Mumin. We are very pleased to hearing from you. Thank you. You have the floor, please.
The chairperson of the African Committee of Experts on the Rights and Welfare of the Child, members of the committee, state party representative, children present, ladies and gentlemen, we the children of Africa take great pleasure to address you on the special day of the children across the continent, and thank you for making this day with a virtual celebration in light of the difficulties due to outbreak of COVID-19. Over 60 children from the continent met virtually on 15th of June 2020 and held discussion related to the theme of this year's daily African child, which is access to a child-friendly justice system in Africa. As we are all aware, children are vulnerable in our society, and this is more so when it comes to justice system, which are designed for and mostly used by adults. There are, however, many children who come into contact with the justice system, either as offenders or complainants. It is important to make sure that the rights of the girls and boys with the specific needs are upheld. In our deliberations on the challenges facing children in accessing a fair, effective, and child-friendly justice system, many issues of concern were raised. In some cases, the length of time it takes for cases to be determined in court is too long, and this denies children speedy resolution to issue affecting them. The delay in consideration of access has been further exacerbated currently due to the COVID-19 pandemic. Some countries have imposed time limitation to ensure children matters are determined quickly, but it will still take a long time in many countries. This affects the children access to other rights, including education, health, as well as the right to play. Many children also come from poor backgrounds, and this limits the access to justice. Many children pointed out that they lack knowledge on their rights and are unable to afford legal assistance when they are in conflict with the law. Lack of legal assistance also means that some children are detained for a long period of time, which makes them lose faith in the legal system. There are also special categories of children, for example, those who live in refugee camps who find it hard to report cases of abuse because they depend on very people that they report these cases to. Children felt that there is lack of sufficient protection mechanisms for those that report.
Children, hearing me? Yes, hello? I think there is some noise in your background. Please, could you please address the situation before continuing, please?
Okay, madam.
Okay, thank you.
Children with disabilities also found it difficult to access justice system. Additionally, some countries do not clearly define who a child is. It is important for all African countries to clearly define a child as anyone under the age of 18 years old in order to make it easier for us to seek justice as children. Finally, there are concerns on lack of investment in child-friendly courts and making various processes in justice system child-friendly. This includes lack of facilities such as toilets and resting places, lack of separate detention places for adults and children, especially girls and boys. Courts also lack appropriate technology video conferencing to ensure child confidentiality, leading to stigmatization of children. Courts are few and far between, and some rural areas do not have children courts. Parents are not able to visit their children when they are detained, which negatively affect the children. Also in courts, there are instances of files being lost or misplaced and documents not being kept confidential, which negatively affect the children. The children put together various recommendations for government to ensure that all children are able to access child-friendly justice system on the continent. Children engage actively in various clubs, such as children parliament, girls clubs, to deliberate on the issues related to the justice system and support each other while in contact with the law. This will give them to have collective voices and ensure for justice. Government should offer more protection to children who are using the established justice system at local and national level. Children issues should be listened to using proper technology such as video conferencing as opposed to face-to-face, and all the information should be kept confidential. Government should promote children empowerment. Children need to know their rights and to be supported to get their rights. Child protection policies should be made widely available and children should be made aware of them. Parents should be educated on the gravity of the offenses against children to avoid instances where cases against children are withdrawn and settled out of court, further harming children. Government should promote child participation in many instances. Children are not consulted and never give their opinion when laws affecting them are being passed. Teachers and parents should be educated to be more friendly to children, even when the children are not in conflict with the law. This will enable the children to learn to distinguish right from wrong. Government should also establish children courts in both urban and rural areas to ensure that all children are able to access justice quickly. This should include training of all actors, such as police officers, courts, and others on child protection and child-friendly services. Social workers should also be available to prepare children for court proceedings, as many as children feel intimidated. Government should also ensure child-friendly justice system, adapting policies and legal documents for children to easily understand interpretation services in court with local languages so that they can speak and listen the court positions. It should be made easier for children to report offences committed against them, especially now with COVID-19, when children are mostly unable to leave the households. There should be functional and free telephone numbers that children can call, and even accessible suggestion boxes. We hope that this measurement will be taken to ensure that children are able to access friendly justice system in all countries on the continent. And thank you for the time.
Thank you, Mumi. In summary, I think 4 keywords from your presentation: information, awareness, inclusion, and protection. That's what the children of Africa are asking for them to be duly considered in the justice system. Now we proceed to the role of media in ensuring access to justice in Africa. And then we kindly invite Mr. Malik Mnela, who is a journalist and author from Malawi. Sir, you have the floor.
Well, thank you very much. My name is Malik Mnela, and I am a journalist based in Malawi. It's actually an honor to be with you, and most of the things that I'll be saying this afternoon have actually been highlighted from various stakeholders' perspective. We've heard those that have a background in the law have to say, and also just immediately we've heard from the child sector what is it that they think. That really lays a solid foundation for what I have to say now. My talk this afternoon is titled From Naming and Shaming to Caring and Reforming, the Role of Journalists in Child Justice System. Specifically, I'll really, in a fast way, try and highlight how we are doing it in Malawi. Obviously, let us start from the known and move probably to the unknown in terms of the role of the media in general terms. The media is known for its role in educating. For example, the media can play a role in educating about the UNCRC, the African Charter, and child justice legislation as we know it. But also it is to inform. On a day like this one, the Day of the African Child, the media becomes critical in highlighting what the day entails. So the role of the media indeed is quite pronounced, but also the media has a main role in setting the agenda. That's one of the critical things that we need to keep at the back of our mind as we discuss and try to shape the discourse in terms of child justice. They also...
Est-ce qu'après les communications, les panélistes on peut intervenir? Merci.
I'm not sure I quite got that on, but also the media can also help shape the narrative in terms of how they shape the interpretations and discourage others, rather discourage other interpretations. Also, the media plays a role in terms of priming, that is to set benchmarks on how we have to, as a society, how we define or look at certain things. Now, immediately, I would like to describe how we as a media in Malawi do function in terms of the child justice. In Malawi, we are fortunate that the law, to some extent, defines the role of the journalist in terms of the child justice system. For example, Section 139, subsections 1 to 5 of the Child Care Protection and Justice Act of 2010 defines the role of the journalist and media houses in terms of how they have to operate, in terms of coverage of children's issues in the child justice system. However, there are limitations in that regard because some of the issues have been highlighted. Perhaps I need not to follow through my presentation in an orderly fashion that I had presented because I understand time is a major issue. So I'll just tackle issues as and when they come to the attention. So in terms of this provision of the law, you'd see that the law outlines the role of the journalist, but also outlines the punishment in terms of what would happen whenever a journalist contravenes or a media house contravenes the law in that regard. But there are limitations. These provisions that are as provided are stipulating how a journalist can cover an issue that is before the courts. Now we have seen that for the most part, we have seen that journalists have not been ethical in their reporting, for example, in terms of how they cover children in the child justice system. For example, upon arrest, in the pre-trial phase, for example. We've seen journalists naming child offenders. We've seen journalists covering images of child offenders. We have also seen journalists identifying indirectly or directly the child offenders. So in a way, this has created challenges in terms of how the media will function. I was privileged to be part of a team that conducted a content analysis in terms of how the Malawian media was conducting, and the findings were inconsistent with what other countries have established. For example, when you talk of children and the child justice system, how are we covering the news? We noted that there was lack of voice of the child in the discourse of the child justice system. We also noted that the coverage was mostly attached to the titillating headlines when children have committed crimes that are considered to be grave. For example, if a child commits murder, for example, you find out that a child is on the front page. If a child is a victim of sexual assault, for example, you find that they are put on front page, or their story gain prominence even on radio. Lack of professionalism is something that I've already highlighted. We have seen that in as much as the Convention on the Rights of the Child, the African Charter, these treaties, in addition to our own legislation, highlighting the need for privacy, we have seen that there is a lack of privacy, a lack of professionalism in that regard. Now, we took a diagnostic approach as a media fraternity, and to try and question why is this happening. We realized that the code of conduct for journalists, for example, is archaic. It was established in 1998. Now, the code of conduct, for example, recognizes a child of 13 years to be eligible for being mentioned, for example, in the news. Now, that poses a challenge because a child now, according to our own laws, is defined as somebody under the age of 18. So the discrepancies that are there are creating conflicts in terms of how journalists operate in terms of professionalism. Now, there is also...
Please, mind the time, please. We are almost out of our time limit. May you wrap up in 1 minute, please?
Okay, in 1 minute. Now, in terms of the lack of CSO and media cooperation, there has been a tendency that also has been corroborated in other countries where the relationship between the media is mostly transactional. We get to be engaged during the Day of the African Child, but the partnership is not strategic in terms of the consistency. So there is need for CSOs, government agencies, international organizations to collaborate in a very systematic way, so that journalists and CSOs operate in a sustainable manner that highlight the challenges that are experienced and encountered in the day-to-day operations, so that things can become better. I think in the interest of time, I have to curtail the presentation. Thank you very much.
Yes, thank you, sir. Thank you, sir, for this very deep presentation, straight to the point, highlighting the challenges, also pointing out of the practice. You said the practice was generally unethical, marked by lack of professionalism. I think the first thing is having conscience, taking cognizance of what is going on. I think is the first step for remedial action. I think you also propose more consistency, also more systematization of the media engagement. We are looking forward to having a fruitful discussion and also fruitful results of your implication in this endeavor. Last but not the least, we'll also call upon one of our major partners, which are the civil society organization. As you know, child rights is not just an issue that could be tackled from one end, and we need to, as I said earlier, combine efforts. So we are now calling to, we are calling the coordinator of the CSO Forum to the African Children's Charter to give us an appraisal of what she thinks is the role of the civil society organization in enhancing children's access to justice system in Africa. Mrs. Felix Tusumo-Chimedi, you have the floor, please.
Thank you so much, Madam Chair, and good afternoon to all the listeners. And I want to observe protocol. Being the last speaker, it's always a challenge because everyone now wants to wind off the meeting. So I recognize the chairperson of the committee, I recognize committee members, I recognize stakeholders, civil society organizations, and I recognize the VIPs of the day, being children. I'm going to briefly be talking about the role of civil society organizations in enhancing access to justice in Africa for children. And perhaps just to start us off to say that the civil society organizations, we are diverse in our nature because we're made up of different organizations that have different compositions. However, we have one identity, which is that of being non-state actors. And because of that, we complement what is happening in terms of government's effort in servicing its citizens or servicing the residents of their countries. But we do play a huge role in terms of the checks and balances, where perhaps we are seen as a watchdog in terms of service provision. We analyze gaps and we lobby and advocate for those gaps to be addressed. We do forge partnerships, although I hear my colleague in the media saying that one of the partnerships we have with them is that of a transactional partnership. But we form partnerships with various stakeholders because ultimately we recognize that more makes credibility and more have more impact. And at continental level, as you said, Madam Campbell, we work with the committee, particularly as a support system to monitor the effective implementation of the Charter. And in terms of what our role is in facilitating or enhancing access to justice for children, One of the things that we are doing as civil society organizations is that of facilitating education and legal awareness for children to know their rights, but also for families to understand their responsibilities as well as the communities. And we do that through the various interventions. And with that education and awareness raising, we also do ensure that there is understanding of the justice mechanisms at country, regional, and continental level. We facilitate child participation. As you've seen, the 2 children who were participating today have been part of the CSO forum from day 1. And yesterday we had a meeting with them, and that is to ensure that we can facilitate understanding and that they can provide insights into our interventions. And we do that with all in and out of school children. We do document child rights violations through the various structures that we have. We have human rights defenders at community level. We have paralegal structures that facilitate for that documentation to happen. We provide service provider trainings, particularly for justice providers, whether you're talking the police, you are talking other professions like social workers and so forth. And we also monitor activities of non-state mechanisms, ensure that they are a rights-based approach interventions and that they do not violate children in any way. And we do provide legal assistance in some instances where we can actually coach children to self-act. We can get them to have an attorney representing them. And in some instances, we actually do a strategic litigation, because we believe that the impact of strategic litigation in areas where the case might be of national interest, of continental interest, because we feel that at that stage it would set jurisprudence. And we also facilitate court preparedness for children who are going through the justice system, whether they are going through that as alleged offenders, as victims, as witnesses, or as any other form. And in terms of strategic litigation on child rights issues, we are seeing that as much as we are talking about strategic litigation as a means that can have an impact, because it would be addressing issues of children in larger groups, we are seeing that strategic litigation is underutilized in Africa, and we do have very few countries that are utilizing that. At this point, South Africa is one country that comes to mind in terms of their ability to use strategic litigation as a way of having an impact on the lives of children and setting new jurisprudence insofar as children's rights is concerned. And there are gaps, Madam Kembo, that we are experiencing as civil society organizations. One of those is the fact that as civil society organizations, particularly those that are within the human rights sphere, we are seen as organizations that are driving a foreign concept within the sector of children, and that we are instilling the rebellion character within children. And also one of the challenges we are facing is the conflicting laws at national level by African member states. We also do have legal jargon as a problem where comprehension of this really is difficult. Even at the African Charter level, we have to rely on general comments as a way of facilitating the understanding of some of the provisions that we have. And then the prolonged judicial system process. Various speakers have talked about this, but from a civil society perspective, right from investigation of these cases to social inquiry report to the stage where we actually can go to court for prosecution, we find that the system itself or the process itself is very long, that ultimately denies children to have access to justice. And we have semi-skilled service providers. There are very few service providers, Madam Kembo, who are able to really talk to children, who are able to seek issues of consent, confidentiality, and understand that exposure of children's cases have a long-term effect in their lives. and the withdrawal of matters by adults when children are involved in certain cases, particularly those that are to deal with sexual abuse and so forth. We find that many adults and parents or guardians use the norm in Africa where we say we can address this issue at home to then suppress and withdraw some of these cases.
Hello.
And then lastly, in terms of the gaps, we see that the root causes of the inadequacy in the judicial system is also led by root causes on accessibility, where some of the courts really are in cities and those that are in rural areas find it challenging. The language used as well, there is no braille, there is no sign language, and there is no local language used. The affordability as well, where there are no legal clinics or civil society organizations to provide such, can become a problem. And poverty is also a driving force in terms of whether or not children can have access.
Can you hear me, please?
Yes.
Yes, please, may I kindly request that you wrap up like in 30 seconds because we are already out of the time, please.
No problem. Thank you. So as civil society organizations, today as we commemorate the Day of the African Child, we are pledging that we'll continue to facilitate education and awareness, that will continue to hold governments accountable on the frameworks to facilitate access to justice, and that will continue to use strategic litigation as a way of ensuring that there is policy reform at national level, but that in turn, if we are found to be wanting in terms of the interventions we are providing, we should also be held accountable. And lastly, we remain vigilant and proactive in ensuring that we have an Africa that is fit for children. Thank you so much for having us on the webinar, and we remain a partner to ensuring that the charter is implemented. Thank you.
Thank you a lot. I think we note the pledge, and then we just, from the part of the committee, just tell you that we greatly appreciate the role of the civil society and the support of the civil society to the work of the committee. So all in all, this panel has enabled us to hear from the children, to also hear from a major practitioner on how they are dealing with the right to access to information on children and how to protect the children in this regard. We have also heard from a civil society coordinator, the coordinator of the Civil Society Forum to the African Children's Charter, and she pledges to continue supporting the implementation of the Charter. With this, we are coming to the end of this fifth panel. As you may have noticed, we foresaw an activity of 3 hours, and we are now about more than 1 hour above the time limit we've set for our own self. I think we may kindly plead that you allow us to wrap up. Before wrapping up, I will kindly invite Mrs. Samrawit from ASWED Secretariat to give us like a summary of the debate that we're having throughout the 5 panels. Samrawit, you have the floor. Please kindly remind us of the outcome of our discussion and the draft declaration, please.
Thank you, Chair. Can you hear me?
Yes. Perfectly, we are hearing you.
Yes. Okay, thank you, honorable members of the committee and distinguished participants. I will briefly present the outcome of DAC 2020, which is prepared in the form of a declaration, a zero draft declaration for your consideration, feedback, comments, and finally adoption. It contains the preamble and recommendations, and I will skip the preamble part for time, but it mainly summarizes the deliberations and recognizes the relevant norms and standards, the good practices, the challenges and concerns raised. Going straight to the recommendations, I'm assuming that you can see the screen, my screen that I've shared.
Oh, we can see, yeah.
Okay, thank you. So as primary duty bearers, the first list of recommendations goes to member states. I will just read it. Okay, thank you. To member states, well, after the preamble, it says, we hereby urge the following stakeholders to take the necessary measures to ensure access to child-friendly justice systems. To member states, harmonize and align national legislation on justice for children, customary law, and traditional justice systems with the African Charter on the Rights and Welfare of the Child, and other relevant regional and international norms and standards. Set the minimum age of criminal responsibility at minimum of 12 years and gradually endeavor to increase it. Ensure that the death sentence is not pronounced on children. Ensure that the best interest of the child is the primary consideration for all proceedings, civil, criminal, administrative, and judicial, involving children, and ensure that there are necessary psychosocial safeguards to protect the rights and welfare of children in such proceedings. Ensure that judicial and extrajudicial proceedings involving children are executed expeditiously and with confidentiality. Establish well-resourced child-friendly courts and ensure that the training of personnel of the justice system on children's rights. Provide legal aid that is decentralized to all regions of countries for all children in conflict with the law. Ensure that justice systems are gender sensitive, responding to the specific protection needs of girls. Provide for the availability of diversion programs focused on education and rehabilitation of children in conflict with the law. Invest on comprehensive specialized justice systems for children. Create enabling environment for civil society and children to ensure accountability on justice for children. To civil society organizations, strengthen the capacity of children as right holders to ensure the justice system in their respective countries, to engage in the justice system in their respective countries, support member states financially, technically, and in any other way possible in ensuring the availability of child-friendly justice systems, collaborate with the African Committee of Experts on the Rights and Welfare of the Child to address challenges in access to justice for children using the key mandates of the committee, which are consideration of states reports and CSO complementary reports, consideration of communications or individual complaints and on-site investigations, and build the capacity of key personnel in the justice system delivery on child rights and principles of child-friendly justice. And finally, to media, to ensure that the plight of children remain on the political agenda through ethical coverage of children, to create platforms for children to contribute content to their media products. This is a zero draft for your consideration, comments, and feedbacks, mainly on the content of the recommendations, because the other issues will be corrected as it's a zero draft that was just written now based on the deliberations. Thank you, Chair.
Thank you, Samharit. I think all participants have now before them the draft outcome statement of our deliberation. And then I'll kindly invite each and every one to forward whatever comment you have on it to the Secretariat so that they compile it to come out with a good document that reflects the deliberation that we are having since more than 3.5 or 4 hours now. So that's the way forward with this outcome statement. Donc, je disais que les uns et les autres sont invités à partager les éventuels commentaires qu'ils auraient sur ce projet de déclaration pour qu'il puisse être amélioré par le secrétariat. Maintenant, au terme de cette longue journée, je voudrais inviter Madame Sindikou, membre du comité et vice-présidente du comité, qui nous a fait l'honneur de prendre la parole au début pour nous ouvrir les portes de cette importante session. Nous lui remettons les clés pour que, comme elle a ouvert les portes, qu'elle puisse également les refermer. Madame Sidikou, vous avez la parole. Merci.
Merci, Madame Kembo. Et chers enfants, honorables membres du comité, chers invités, mesdames et messieurs, tout protocole respecté. Nous voici au terme de la commémoration continentale de la Journée de l'enfant africain, édition 2020, sur le thème « Accès à une justice adaptée aux enfants en Afrique ». C'est un agréable devoir pour moi d'adresser ma reconnaissance à toutes et à tous pour l'intérêt accordé aux points essentiels inscrits à l'ordre du jour de cette commémoration. Durant cette journée, vous avez écouté les différents panélistes qui ont partagé avec nous leurs expériences et bonnes pratiques et qui ont suivi avec assiduité et beaucoup de sérieux et d'intérêt la commémoration sur le thème de cette année, témoignant ainsi de l'importance que vous avez accordée au problème de l'accès à une justice adaptée aux enfants sur notre cher continent. Aussi, depuis plus d'une trentaine d'années, le comité s'est toujours engagé sans relâche pour un mieux-être des enfants avec l'appui des États parties et des organisations partenaires qui n'ont ménagé aucun effort pour améliorer leur sort. En cela, je voudrais relever le rôle majeur joué par tous les acteurs permettant d'accomplir des efforts appréciables en matière de protection et de promotion des droits de l'enfant. Chers enfants, mesdames et messieurs, ainsi comme vous avez pu le constater, on relève d'une manière générale à travers les présentations des États membres que les instruments internationaux et régionaux sont majoritairement ratifiés, que les politiques et législations nationales sont disponibles et en faveur des enfants, que des efforts ont été accomplis dans plusieurs domaines tels que ceux liés aux droits et libertés de l'enfant, la protection judiciaire et la protection de l'enfant contre certains fléaux. Néanmoins, en pratique, la mise en œuvre des droits de l'enfant rencontre toujours des difficultés spécifiques qui leur sont propres et qui restent encore sans réponse. La place d'un enfant n'est pas en prison et n'oublions pas qu'un enfant reste un enfant. Cependant, face à l'intérêt suscité par les débats d'aujourd'hui, l'espoir reste permis au vu des progrès enregistrés sur la mise en œuvre de la Charte en Afrique. C'est pourquoi je demeure convaincue que grâce à vos efforts inlassables et continus, les droits des enfants seront mieux garantis. Je vous invite par conséquent à prendre les mesures idoines pour que l'on puisse atteindre les objectifs de l'agenda 2063 de l'Union africaine et de l'agenda 2040 pour les enfants d'Afrique. Chers enfants, mesdames et messieurs, je voudrais aussi adresser encore une fois mes félicitations pour votre attention soutenue pendant cette commémoration et pour la qualité du travail accompli au niveau de chacun de vos pays. Cette discussion nous aura permis de percevoir et de comprendre nos forces et nos faiblesses en vue d'apporter des réponses concrètes et de chercher des solutions dans le meilleur intérêt des enfants africains. Les points saillants du projet de déclaration qui a été présenté seront présentés à tous les États membres et organisations partenaires. Aussi, le comité attend des États membres qui ont commémoré la Journée de l'enfant africain cette année, conformément au thème adopté par le Conseil exécutif, d'envoyer un rapport selon le canevas joint à la note d'orientation. Cela permettra au comité, au cours de sa prochaine session statutaire, d'apprécier l'impact du thème de cette année et aussi les progrès réalisés dans le cadre de l'administration de la justice pour mineurs. Avant de terminer mon propos, je voudrais réitérer mes sincères remerciements aux partenaires qui ont appuyé le comité dans l'organisation de cette journée de commémoration, notamment Plan International, Save the Children et tous les participants en ligne. La pandémie actuelle ne nous a pas permis d'être physiquement ensemble, mais néanmoins, nous tenons à remercier les États membres de l'Union africaine qui avaient déjà offert d'accueillir la commémoration de cette journée. Je voudrais encore dire merci à la République de Guinée, du Kenya, du Zimbabwe pour leur invitation d'abriter la commémoration continentale cette année. Nous espérons que vos offres seront toujours valables les années prochaines. Un grand merci aux collègues membres du comité, aux délégations des États membres et à leurs partenaires, aux interprètes, au personnel du secrétariat du comité pour l'appui technique qui a permis l'organisation de cette présente session. En souhaitant à tous et à toutes une bonne journée de l'enfant africain 2020, je déclare close la présente commémoration continentale de la journée de l'enfant africain. Je vous remercie.
Merci, honorable, de bien clôturer cette belle journée de l'enfant africain.
Thank you.
Toutes les félicitations.
Everyone for having taken your time to be with us for this meeting. And the outcome document is adopted as amended.
Amended.
So we have tomorrow to send your comments, and then we will add them to the draft outcome statement and share with you. Thank you so much. We are so grateful. Take care. Take care. Wash your hands and keep distance.